we start with the advertisement. The advertisement says that there are 90 vacancies. So this year's law clerks panel will consist of 90 candidates who clear the exam and the top 90% who get the ranks. Out of this 90 candidates panel, some of the candidates are going to be placed with the judges, some of the candidates are going to be placed with the registry, and the remaining candidates in this 90 law clerks panel will be put in the wait list to be adjusted for any future vacancies that may arise during the course of the panel's validity. Now, besides this, let's just look at the schema of the examination. I think so it's somewhere over here only. I can't find it. Okay, yeah, it's over here. So now before going to the schema of examination, let me give you a disclaimer that even if after the session we are not going away, we are not disappearing. If you have any doubts, you can approach us on LinkedIn. Me, Satyam, Arif, we are all there. You can approach us at any time, no matter what doubt you have. Irrespective of the fact whether you have doubts even after attending the session, if you're watching a recording or you could not even attend the session, we are here to clear your doubts. You can approach us at any time on LinkedIn. As and when we are free, we're going to try to help you out. Although we are not going to be probably making another session because of course we don't have enough time, but in terms of clearing doubts and helping you guys, that's not going to stop even if we stop making sessions. Okay, so besides this, now let's get back to the schema of examination. So like you know, the examination is divided into part 1 and part 2. If you qualify part 1, then your part 2 results are also taken into consideration. Part 1 and part 2 are both conducted on the same day. Part 1 is basic MCQs carrying 0.25 of negative markings, and it consists of your main subjects: Constitution, CRPC, CPC, IPC, Evidence and Contract. And besides this, it consists of English comprehension, latest case law developments and general awareness. Now this general awareness is different from the previous year papers, which I'll get to later on. Besides this, you have the part 2, which is brief making and preparation of research memo. And even besides that, there's a new third question, the analytical question, which is synonymous to how the daily judicial main services goes. Okay. Besides this, तुम्हारे ये जो GK वाले question है, like let's say in 2014 India signed a civil, these will not come. Only legal GK is relevant. कि latest case laws में क्या हुआ है, what kind, who is the latest judge to be appointed in Supreme Court, what is the current strength of Supreme Court, who are the members of the collegium, या फिर you can even take for example, let's say what are the cases which are being streamed by the Supreme Court. So like these kind of जो general GK वाले हैं ना, अब ये सब आते हैं, not these kind of thing. तो अगर तुम लोग UPSC या जुडिशरी का भी GK वाला किताब उठाओगे for the purpose of general awareness, ये सब बिल्कुल भी relevant नहीं है. Now let's go, क्या कहते हैं, previous year के पेपर में ही चले जाते हैं. Now I won't be going into कि क्या question इसका क्या आंसर हो, ये सब नहीं होगा. I'm not doing a paper analysis per se, but I'll tell you what all things to look out for. Number 1 would be indirect questions will be asked. So instead of saying which of the following is correct, they'll ask which of the following is incorrect. You'll see ये बहुत ज़्यादा होगा, so be sure to read the paper correctly. ठीक है. कुछ जगह पे होगा what is false, which one of this is incorrect. ठीक है, ये सब होगा. I'll share the last year का paper, that won't be any problem. You can go through it. And again you'll see one more thing over here is कि कोई भी like direct section नहीं पूछे. They are not asking what does section 9 of Arbitration Act or section 11 of Arbitration Act says or section 34 of IPC says. They'll give you the entire provision. You can see यहाँ पे भी पूरा provision दे रखा है इन्होंने. ठीक है. And they'll ask you to apply this. ठीक है. This is the factual situation where you have to apply the section. Now they can do few things also over here. They can change certain words in the section. So now you'll have to be sure and read it कि भाई what is the section in the paper saying. Don't apply your general knowledge what you know about the provision. You'll also have to correlate it with whatever is reproduced in the paper. So इसका I'll give you an example, but like although I'm not saying कि questions sections के questions नहीं आएंगे. There are instances like एक दो question आते हैं जिसमें directly पूछे थे what does section 9 say, what does any of this section says, but mostly are application based only. तो like concept से ज़्यादा focus करो, provisions का rote learning करने का ज़रूरत होगा नहीं. Most of the time तुम्हें provision देंगे. Like you can see over here also section 60 CPC दे रखा है, section 11 दे रखा है. They are giving you the entire section. They are not hoping that you mug up all the sections. Next comes latest development. Latest development guys, प्लीज़ फोकस करना ज़्यादा बिकॉज लेटेस्ट डेवलपमेंट पे बहुत ज़्यादा एम्फेसिस होता है. लाइक मोस्ट ऑफ द क्वेश्चंस लेटेस्ट डेवलपमेंट्स पे ही आते हैं. इफ यू रीड लाइव लॉ, सुप्रीम कोर्ट ऑब्जर्व एंड अदर दीज काइंड ऑफ थिंग्स, यू विल बी इजीली एबल टू क्रैक दिस. ठीक है. आई विल टेल यू लाइक ऑनेस्टली, लाइक मेरे में भी जब मैं लेटेस्ट डेवलपमेंट्स वाला पार्ट वॉज द वन पार्ट जिसके अंदर मेरे लाइक ऑलमोस्ट 99% सब करेक्ट आए थे. एंड इसके अंदर भी ऑफकोर्स दे आस्क यू डबल नेगेटिव और इनडायरेक्ट क्वेश्चन की विच स्टेटमेंट इज फॉल्स ओवर हियर. So be sure to keep that in mind. इसके अलावा one more thing that I wanted to show you, right? English comprehension is this? Yes. Now coming to English comprehension, instead of giving you a normal like ordinary paragraph that exists, ठीक है, कोई भी normal in general का, they'll give you a legal paragraph. So like let's say constitutional assembly के debates देंगे या judgment का कोई excerpt दे देंगे, and from that they'll ask you questions. So this is tad bit easier than the previous year papers because उसके अंदर normal English के पूछ रहे होते, तो you don't really have anything to understand. Over here you already know कि debates में mostly क्या बोला गया है for let's say universal franchise पे, या फिर you already know कि इस judgment ने क्या बोल रखा था. तो it's much more easier to answer questions, especially questions जो पूछते हैं which of the following is more consistent with the argument. So like which amongst the following is consistent with Dr. Ambedkar's argument. So now you already have a background of Constituent Assembly के debates में क्या बोला था when you would be studying Constitution. You are in a better position to answer it. And इसी से like they'll ask you कि what does the passage mean या what does this expression means, and these kind of things will come in English. So like axe to grind का मतलब क्या हुआ. So this is how you'll have to answer it. These are your English comprehension के questions. सेम विद क्या कहते हैं नेक्स्ट क्वेश्चन वाला भी 2 इंग्लिश कॉम्प्रिहेंशन के क्वेश्चन आते हैं, मतलब लास्ट टाइम तक आए थे. दे कैन चेंज इट ऑब्वियसली. इसके अंदर दे आस्क्ड फ्रॉम पुट्टस्वामी के जजमेंट में से. सो लाइक यू कैन ऑल्सो ऑब्वियसली आंसर ऑल ऑफ देम वेरी इजली. इसका अगेन आईपीसी ये सब तो खाली एप्लीकेशन बेस्ड है. वन थिंग दैट आई वांटेड टू शो यू वाज ओवर हियर. सो लाइक इफ यूल सी दिस इज टॉकिंग अबाउट क्या कहते हैं एन अग्रीमेंट जो लाइक आउट ऑफ लव एंड अफेक्शन बनाया जाता है. Now इसके अंदर what they have done in they have changed section 25 में which says that it is expressed in writing and must be registered under the law. ठीक है. Now this is a change. So like registration under law is not necessarily per se for section 25, but इसके अंदर they have changed the reproduction of the entire section only. तो इसके basis पे you have to answer. So इस question में there was obviously a written agreement, but that there was nothing said about whether this agreement was registered or not. So over here because of this registration वाला part, this not being fulfilled, ये agreement becomes void ab initio. So like this is basically how part 1 works. ठीक है. Do you have any doubts over part 1? I am guessing कोई doubts है नहीं, but in any case अगर होगा भी, yeah.
Yes, I have a doubt.
Yeah, please ask.
This is Krish Bhatia. First of all, thank you for the informative session, and you had took time to tell us everything about the.
No worries.
And just I need to know that you are telling that there won't be an English comprehension, but you have showed one question right now, that which is not related to that paragraph, but it was a comprehensive question. So we have to be ready for that as well, no?
Yeah. So English comprehension, when I say कि English comprehension नहीं आएगा, like ऑर्डिनरी इंग्लिश कॉम्प्रिहेंशन नहीं आएगा. इट्स नॉट लाइक कि तुम्हें कोई रैंडम बुक का कोई इंग्लिश पैसेज देते हैं. देखो वो दे सकते हैं, बट अब दिस हैज चेंज. दे विल गिव यू सम लीगल पैराग्राफ ओनली. सो लाइक कॉन्स्टिट्यूएंट असेंबली के डिबेट, दिस विल कोई असेंबली के डिबेट का एक्सर्प विल कम एज एन इंग्लिश कॉम्प्रिहेंशन, या फिर किसी जजमेंट का पैराग्राफ और मल्टीपल पैराग्राफ्स विल कम एज ए इंग्लिश कॉम्प्रिहेंशन, एंड उसी से क्वेश्चन पूछा जा रहे होंगे.
Romit, may I add?
Yeah, please.
So in last Sam, what they have done is they have extracted a speech of Dr. B.R. Ambedkar, and they have asked questions from that speech. So it is related to constitution and law in some way. So it was not a random English comprehension. They'll give you comprehension, but it's going to be related to either constitutional law or a constitutional debate or any particular judgment they may also give you. So you have to be prepared for it rather than preparing for general English comprehension.
Okay, we have to take care of all the judgments which are related to Supreme Court and all the political leaders who were involved in that.
That is relevant for latest case laws. So latest case laws के लिए तो तुम्हें cases करने ही है सारे. But like जो English comprehension में आएगा उसके अंदर ये already काफी famous judgment होगा. Like everybody knows पुट्टस्वामी ने क्या बोल रखा है.
Yeah, I understood.
Yeah. Ashish, you have a doubt? Please go ahead.
Yes, initially at the starting of this session, you told about that list of cases has been provided on the website of the Supreme Court. So can you please share a little bit more about that?
I'll do that. Don't worry, I'm coming to that only. So now I'll go to
Romit. One question I had.
Mm-hmm.
Would you suggest that for this MCQ portion of the paper, do we need to peruse through capsules of IPC, CRPC evidence, and for that matter, all the
What
other
do you mean by capsules?
Capsules as in capsule courses, or for that matter, something of a summary or a brief.
Yeah, definitely you should do that.
Yeah.
We'll come
how
to
do we
the
go about the statute related questions per se?
so we'll come to the preparation part थोड़ी देर में. पहले first we'll
अच्छा, okay, no problem.
tell you कि क्या questions आएंगे, what are you even up against, ठीक है?
Definitely.
Alright. So now let's come to क्या कहते हैं कि latest case laws वाले पे आ जाते हैं. So this is the list of relevant cases जो यहाँ पे आ रखे, ठीक है? बहुत सारे पुराने cases भी है. टेक फॉर एग्जाम्पल जोसेफ शाइन वाले जो अपडेट हुआ है बस खाली वो सब आ रखा है, ठीक है? यू हैव सुप्रिया, यू हैव एनिमल वेलफेयर बोर्ड जो जलीकट्टू वाला जजमेंट था जो पिछले साल भी आया था, इस साल भी इन्होंने दे रखा है 370 सेम सेक्स मैरिज, एन ग्लोबल जजमेंट, ठीक है? बहुत सारे ये सारे लिस्ट है. ये सारे लिस्ट तो तुम लोग थरली प्रिपेयर कर लेना. लाइक बिसाइड्स द रेशियो ऑल्सो यू विल हैव टू क्या कहते हैं ऑल्सो सी कि मेन इशू क्या था, विच प्रोविजन वर इन इशू, ठीक है? एंड इंसिडेंटली इसने और भी चीज़ें क्या क्या होल्ड किया एंड किन किन और जजमेंट्स पे दे हैव रिलाइड अपॉन, लाइक मेजर रिलायंस किन और जजमेंट्स पे है. तो ये सब तो आएंगे ही आएंगे, ठीक है? दिस इज अवेलेबल ऑन द सुप्रीम कोर्ट साइट, यू कैन डाउनलोड इट वेरी इजीली. इसके अलावा नाउ दिस इज इन माई ओपिनियन नॉट एन एग्जॉस्टिव लिस्ट ऑफ केसेस जो आएंगे. देयर विल बी मोर केसेस ऑल्सो जो क्या कहते हैं लेटेस्ट केस लॉस के अंदर वन लाइनर की तरह पूछ सकते हैं, लाइक व्हाट डिड दिस डिसीजन से, या व्हाट डिड दिस डिसीजन से, या इन विच डिसीजन दिस वाज हेल्ड, ठीक है? तो उसके लिए आई हैव प्रिपेयर्ड लाइक अ वेरी क्या कहते हैं इनफॉर्मल लिस्ट जो आई थिंक सो इज ऑल्सो लाइकली टू कम, ठीक है? यू हैव योर प्रिया इंदौरिया जजमेंट बाय जस्टिस नागरत्ना, ट्रांजिट एंटिसिपेटरी बिल, कॉक्स एंड किंग्स बाय जस्टिस चंद्रचूड ऑन क्या कहते हैं वैलिडिटी ऑफ कंपनीज डॉक्ट्रिन. अगेन दिस IBC पर्सनल गारंटर्स वाला अनिल अंबानी वाला मैटर, ठीक है? रेट्रोस्पेक्टिव बेनिफिट ऑफ इम्यूनिटी अगेंस्ट अरेस्ट ऑफ जस्टिस अब्दुल नज़ीर, पंकज बंसल वाला डिसीजन ऑन क्या कहते हैं ED टू फर्निश ग्राउंड, सेम सेम NDPS में भी रिटन राइटिंग में क्या कहते हैं फर्निश करने ग्राउंड्स सेक्सुअल हरासमेंट पे, ठीक है? ये सारे जजमेंट्स भी मेरे को लगता है लाइकली आएंगे एंड देयर कैन बी मोर जजमेंट्स ऑल्सो. यू विल हैव टू ऑब्वियसली assert yourself and you know go through live law and all of these yourself, but like besides ये लिस्ट तो तुम करके ही जाना, इसके अंदर तो यू विल हैव टू डू एवरीथिंग, नॉट जस्ट द रेशियो बट ऑल्सो लाइक मेन इशूज क्या आते हैं एंड एवरीथिंग अदर क्या कहते हैं अदर जजमेंट्स उसके अंदर साइड किए थे. इसके अंदर यू कैन बेसिकली गो थ्रू द रेशियोज ओनली कि क्या क्या होल्ड किया जाता है. यू डोंट हैव टू गो इनटू द एस्पेक्ट कि किसने ये जजमेंट दिया है, क्या दिया क्या नहीं दिया, इतना ज़्यादा नहीं करना है. इसके अंदर वन लाइनर क्वेश्चन ही आने चाहिए. बिसाइड्स दिस देयर आर फ्यू इश्यूज कॉन्स्टी बेंच के मैटर्स जो अभी चल रहे हैं जिससे रिलेटेड वो पुराने क्वेश्चन भी पूछ सकते हैं. टेक फॉर एग्जाम्पल AMU वाला केस. AMU वाले केस में देयर वर अ प्लेथरा ऑफ डिसीजंस ऑन आर्टिकल 13 एंड इट्स इंटरप्रिटेशन. वो 100% उनमें से कुछ ना कुछ तो पूछ सकते हैं, बी इट अजीज बादशाह इन रेफरेंस टू केरला लॉ, सेंट जेवियर्स केस, सेंट स्टीफेंस केस, जो भी. देन देयर वाज अ 7 जज मैटर पहले भी चल रहा था सीता सोरेन वाला ऑन पार्लियामेंट्री प्रिविलेजेस. उस पर भी जो उसके पुराने जजमेंट से जो कॉन्फ्लिक्ट कर रहे हैं नहीं कर रहे, दे कैन आस्क यू ऑन दैट ऑल्सो. अभी सेक्शन 6 से सिटीजनशिप का भी चला था, उसके अंदर भी देर आर फ्यू केसेस ओनली बट है. सोनोवाल केस नंबर 1, सोनोवाल केस नंबर 2, आसाम पब्लिक वर्क्स वाला जजमेंट जो रेफरेंस अल्टीमेटली कंक्लूड हुआ CB वाले मैटर में. एंड देन ऑफकोर्स जो अभी सबसे रिसेंट क्या कहते हैं कॉन्स्टिट्यूशन बेंच चल रहा है विच इज दलविंदर सिंह वर्सेस स्टेट ऑफ पंजाब, विच इज अ रेफरेंस फॉर स्टेट ऑफ पंजाब वर्सेस दलविंदर सिंह अगेन, विच इज basically trying to introduce creamy layer into the reservation. So then you will obviously have to be acclimated with what is reservation, how do you go about reservation and ये सब. So best sources for preparing for latest case laws is obviously Supreme Court Observer is a good site that you can go through. That just read everything. Supreme Court Observer only gives you the relevant stuff only. लाइव लॉ पे यू कैन रिलाई अपॉन क्या कहते हैं जो भी पुराने क्या कहते हैं डाइजेस्ट और ये सब आते हैं. एंड बिसाइड्स दैट यू कैन ऑब्वियसली कीप ऑन रीडिंग इट टू बी अप टू स्पीड कि अभी सुप्रीम कोर्ट में क्या क्या चल रहा है. SEC blog is also another good place where you can read cases, and there is another site known as Site Case. They also provide good decisions and decisions का अच्छे से dissect करके they give you analysis, so you can place reliance on that also. Besides this, one more thing that for pertaining to general awareness is what I would say is कि make sure कि जितना भी live stream होता है CB के matters, you pay attention to that because last time when I was about to give paper, I was watching क्या कहते हैं ये I was watching same sex marriage का काफ़ी ज़्यादा. तो same sex marriage में there was one tussle where like the Solicitor General had placed reliance on a US Supreme Court decision known as Dobbs versus Jackson. Now Dobbs versus Jackson का बस खाली इतना ही रेलेवेंस है कि वो कॉन्स्टिट्यूशन मैटर के आर्ग्यूमेंट्स के टाइम पे कहीं पे बोला गया था, नथिंग मोर नथिंग अदर देन दैट. बट वो डॉब्स वर्सेस जैक्सन वाला केस यहाँ पे भी आया था पिछले साल के पेपर में. इफ आई कैन फाइंड इट तब अच्छा है, अदरवाइज बट आया था. सो लाइक इफ यू गो थ्रू क्या कहते हैं जितना भी लाइव स्ट्रीम हो रहा है. आई एम नॉट सेइंग कि यू हैव टू गो थ्रू एवरी लाइव स्ट्रीम, बस मजे मजे के लिए जब भी तुम्हारे पास थोड़ा बहुत टाइम है तो चले जाना, ठीक है, और पढ़ लेना. तो उससे तुम्हें पता चले. लाइक अभी रिसेंटली एक जो सीबी मैटर चल रहा था उसके अंदर वन ऑफ द एडवोकेट साइटेड ब्राउन वर्सेस बोर्ड, ठीक है, विच इज रिलेटिंग टू सेग्रीगेशन. तो यू विल हैव टू नो कि ब्राउन वर्सेस बोर्ड में क्या हुआ था एंड ये सब थोड़ा बहुत यू विल हैव टू नो. सो यू कैन डू ऑल ऑफ दिस. I can't find the question. If I'll find it, I'll let you know. Other than that, I think so. Now we can come to brief making, which RF का forte है. RF, please go ahead and do this.
Romit, hi. Just one more thing. Am I audible to everyone?
Yeah.
Yeah, Satyam, go ahead.
I'm so sorry for being so late in the session. On this constitution bench point, I just wanted to add that I think this year has been remarkably great in terms of the number of constitution benches that have been assembled and that have concluded hearing. So I think a lot of questions are going to be asked from the last 6 or 7 CV. Please make sure to at least go through the judgments in the constitution benches in which the judgment has been delivered and the proceedings in which the judgment has been reserved. I think there are at least six after our clerkship paper, at least 6 or 7 CBs have been
Correct.
constituted.
Satyam,
So
I
I'm
think so you
guessing
should explain them AMU wala also. I was like hoping कि you do that. थोड़ा सा
yeah.
like basic idea.
So MU, I think, for example, Article 30 is involved there, Article 29, 30. So there are two types of questions that can be asked. One is they are going to give you a passage, maybe let's suppose HM Sirwai's critique on Article 30 or the judgment which was impugned in the MU matter. So you can either get a comprehension passage which pertains to one of these constitution bench hearings. The one which was concluded yesterday, it pertains to Article 15. Uh, Before that, if we go, the Assam, the Section 6A of the Citizenship Act, it pertains to Part 1 of the Constitution. So all of these CBs have a lot of constitutional significance. So I think you should also, other than going through the proceedings and what happened in the proceedings, what was the judgment delivered, also focus a lot on the articles and the provisions of law which were involved in these constitution bench hearings. Because indirectly they are going to ask you some questions from the sections which were the core of the discussion in these constitution bench
Correct.
papers.
Like 370 वाले decision में, besides obviously asking for 370, they can ask you how the constitution is amendment. कब you need 2/3 majority of the state when you don't need. Same in क्या कहते हैं AMU वाले में they can ask you कि schedules के अंदर क्या distinction है, what is the purpose of a university of national importance. So like these kind of things
True, true,
आ सकते
true.
हैं. Very rightly
What is the
said.
entry which pertains to Aligarh Muslim University? So that would be list 1 of Schedule 7, entry number 63. So they can probably ask you this question or questions along these lines.
बट ये कोई भी आउट ऑफ द ब्लू नहीं पूछेंगे, जो भी चल रहा है आजकल उसी से पूछेंगे. प्लीज आरिफ गो अहेड. सॉरी फॉर
Okay, so hi everyone. I'm Arif. I'm currently associated with Chambers of Honorary Justice Mehta. और अभी मैं उन्हीं की चैम्बर में बैठा हूँ. तो सर आ जाए तो मैं डिस्कनेक्ट कर सकता हूँ एकदम. तो सो सेकंड पेपर इज द स्कोरिंग मार्क्स. इट्स 300 मार्क्स. तो पहला जो मैं कहूँगा, यू शुड कीप इन माइंड दैट देयर इज अ रेस अगेंस्ट टाइम. आपको 3 घंटे में यू हैव टू अटेम्प्ट 3 क्वेश्चंस और उसमें यू डोंट हैव टू मेक एनी मिस्टेक्स. क्योंकि इन आर टाइम आई विल शो यू द क्वेश्चन पेपर ऑफ आर कि उन्होंने काफ़ी गलतियां कर दी थी. टू कंफ्यूज हो कि गलतियां हो जाती हैं या जानबूझ के की है उन्होंने, वो पता नहीं, पर उन्होंने की थी ताकि आप गलत करो या कंफ्यूज हो ताकि टाइम ज़्यादा लगे. सो आई विल शेयर क्वेश्चन पेपर ऑफ लास्ट ईयर. तो विल गो थ्रू. So this is the part 2, subjective written examination, and this is your question number 2. First question starts. So this is synopsis of and list of dates. So Romit and Satyam, if you like to add something, you can tell, like you can discontinue और बता सकते हो बीच में कि इशू आ रहा है, क्योंकि मेरा नेटवर्क
Yes, bro. I will intervene and tell if there's something that I want to share.
क्योंकि मेरे नेटवर्क में थोड़ा
Yes,
इशू
yes,
आ
no
रहा
problem.
है. Okay. So this is a list of dates. This is the synopsis. This is list of dates. So this issue is related to property and specific performance of the contract. So starting with list of dates, then you have your impugned judgment. So this is standard SLP which you have in Supreme Court. First you have synopsis, then you have list of dates, then you have impugned judgment. Impugned judgment is judgment that has been challenged before the Supreme Court. Then you have your SLP. From here your SLP starts. This is a memo of parties, the parties which are before the Supreme Court. And here you can see that this is the stance of the parties in the High Court and this is the stance of the parties in the Supreme Court. So you must be aware which parties first approached the court, which then went to the appeal to the High Court, and then they come to the Supreme Court. So in every SLP there needs to be a question of law. You have your question of law at what is the question of law before the Supreme Court, and why are they challenging the Supreme Court judgment or the High Court judgment. These are the grounds they are challenging upon. Then you have your prayer, and then you have appendix, the sections or the statutory sections they have relied upon in the case. You have annexures, annexure 1, annexure 2, then you have your annexure 3, and then I think this is not complete. Then you have your application for condemnation of delay, that is not relevant for our case. So usually what I like to start with is to get a brief idea of case. I like to start with the impugned judgment because you'll get the whole case brief from the impugned judgment. So this case,
Yeah, the only disclaimer is that that is subject to how well of a judgment the court whose order is impugned wrote that judgment. So in some cases the impugned judgment is very cryptic. They hardly write 2 or 3 pages and simply dismiss the matter, allow the matter, which is then appealed in Supreme Court. In those cases, you have to rely on the annexures and the synopsis and list of dates to sort of get an understanding of what the matter was. But if it is a decent judgment which has been challenged, then you will get most of the information that you need for the purpose of the brief from the impugned itself.
so yeah, this is present, this impugned judgment. So it came as a regular second appeal before the Honorable High Court, and it was preferred by Shri Shanti. Shri Shanti is petitioner in the Supreme Court. She is also a plaintiff. So you have to understand who is plaintiff and who is petitioner, who is defendant, who is respondent. So plaintiff is a person who initiated the first suit before the trial court, and petitioner you use for someone who has approached now the Supreme Court. So in this case, they have given the brief facts of the case. Brief facts starts with the appellant before the High Court. Shri Shanti, being a plaintiff, filed a specific performance on 10th of September 2002. So you can also check from here. They have written 10th of November 2002. This is the specific performance of the contract, the suit that she filed. And before that, you'll go that there was agreement. So I'll start with the list of dates first. There's agreement which happened in 8th of August 1992. Agreement to sell between the petitioner. You'll find that petitioner is also plaintiff. The petitioner in Supreme Court was also a plaintiff who initiated the first suit, and respondent. So first agreement was between petitioner, plaintiff and respondent through his power of attorney, respondent number 2. So respondent, you need to take down that you keep the memo of parties correct, because if the memo of parties is not correct, then your brief will be very confusing. So you can also use slashes that petitioner hearing was plaintiff original. So agreement was between petitioner and respondent through power of attorney with respondent number 2 for sale of this property situated at this district. So you can use disputed property. So if there's only one property, you can use disputed property. You don't need to write the whole details of the property every time you write the property, because this will defeat the purpose of a brief. So use disputed property for sale consideration of this rupees. So in 1995, there were some floods, there was some dispute between the parties. In 1997, what defendant, so they have not written defendant number 1. They have only wrote only defendant here. So you have to make sure you write defendant number 1, because there is difference between defendant 1 and defendant 2. So you can check this from the initial annexure 1. Annexure 1, they have written defendant number 1. Defendant, through his GPA, respondent number 2, sold away the disputed property to respondent number 3 by way of sale deed bearing this. So now you have two sale dates, one of 1992 where petitioner sells property to respondent number 1. Then you have another sale date where respondent number 1 sells property to respondent number 3. Now what happens is in 1997 petitioner files a civil suit against respondent number 2 and one Om Prakash for permanent injunction restraining defendant from interfering with peaceful possession of plaintiff petitioner over the suit property. Now they have added a new party, that is Om Prakash. So we'll get to know who Om Prakash is. So you'll find if you go to annexures, annexure number 1. So annexure number 1 is defendant number 1 in this, in the initial suit that was filed before the civil judge of Monaco. And you have Santlal, that is defendant number 2. They have not written defendant number 1
Arif,
there.
can you just go back to annexure 1? I just wanted to show something that you told in the beginning. So, as Arif told that they either deliberately or because of some clerical error, they tend to make mistakes in the name or list of dates that they have given. So earlier they were using Shanti
Shanti.
everywhere.
Now they have written
And now
Shakuntala.
suddenly you see that the petitioner in this case is Shakuntala, wife of Shri Kevaldas. And they keep on switching between Shanti and Shakuntala in this entire question paper which was given to us last year, which caused me to lose a lot of time. So I ended up wasting around 25-30 minutes figuring out who Shanti and who Shakuntala is. And I also had to cut certain paragraphs from my briefs, which ended up making it look very messy. So I think on this you have to trust Arif that they can make mistakes and you have to sort of either overlook it or you have to ignore it.
So we were in 1997 when petitioner and petitioner plaintiff filed a civil suit before civil judge for restraining Om Prakash in peaceful possession. Then in 2001, civil suit number 486, which was filed in 1997, was decreed. True copy. So they have not written what the judgment was. So you will have to go through the annexure to find what the judge has delivered. So you'll go to annexure P1. You'll find so this judgment P1 is ex parte. Notice of the suit was given to the defendant, but defendant opted not to contest the suit. It shows that they have not interest in the property. Otherwise, also from oral as well as documentary evidence, the plaintiff have proved her ownership. So because this case was not contested by the defendants, plaintiff has proved her ownership and possession of the suit. So obviously this will be challenged by the respondents now. So, this was decreed ex parte in favor of petitioner and plaintiff. Being agreed by the judgment and decree dated of 25th of November 2011, passed by learned civil judge, respondents herein filed a civil appeal of civil appeal number 282 RBT of 2011 and 2014 before learned district judge. So you will see petitioner also filed a civil appeal because in here only part relief is given. It has in the annexure P2 has been said that although she has possession of the property, but specific performance was not given. So two appeals were filed from it. Learned district judge on 14th of November 2014 allowed the civil appeal number filed by the respondent herein and set aside the judgment. So you will see they have written set aside the judgment of 21st ऑफ मई 2016. ये गलत लिखा हो ना, टू कंफ्यूज यू. वी आर स्टिल इन 2014. इन्होंने 2016 की जजमेंट कैसे ओवर रूल कर. सो यू कैनॉट रिलाई अपॉन द लिस्ट ऑफ दिस सोलली. जो मैं पहले बात कह रहा था कि एलओडी में काफी गलतियां करते हैं. अगर आप ये देखोगे तो इन्होंने गलत किया. यहाँ होना चाहिए 25 नवंबर 2011. तो यू हैव टू सी. अगर आपने जल्दी जल्दी में ये लिख दिया तो ऑब्वियसली द एग्जामिनर इज गोइंग टू चेक इट. हिल और शी विल कट द मार्क्स. तो आपको इनके थ्रू जाना चाहिए एक बार. मतलब टू चेक दिस थ्रू यू हैव टू गो टू एन एक्सर P3. एक बार P3 पे जाके कंफर्म कर ले कि कौन सी जजमेंट को ओवर रूल किया है और किसके फेवर में किया है. So if you go to an extra P3, सो जजमेंट में इन्होंने स्पेसिफिकली लिख लिया है कि द जजमेंट ऑफ माइन शैल डिस्पोज ऑफ द रेफर्ड सिविल अपील्स विच हैव बीन प्रेफर्ड अगेन जजमेंट ऑफ 25 नवंबर 2011. तो आपको यहाँ से अपनी इंफॉर्मेशन लेनी है, ना कि लिस्ट ऑफ डेट से. वहां पे उन्होंने 2016 का लिख दिया कि 2014 में 2016 की जजमेंट को ओवररूल कर दी. तो यू हैव टू गो थ्रू द नेक्स्ट, वहीं से आपको अपनी प्रॉपर इंफॉर्मेशन मिलेगी. सो इन दिस जजमेंट व्हाट दे हैव डन, by common order, both the civil appeals filed by the respondents and the petitioner in the present case, the appeal of respondents was allowed and judgment of 25th of November 2011 was set aside. So against annexure P3, the judgment of additional district judge, the petitioner preferred regular second appeal 5173 before the Honorable High Court of Punjab and Haryana Chandigarh, and this judgment of High Court is challenged before the Supreme Court. In impugn what they have said, the agreement, the initial agreement was executed in 1992 and the appellant plaintiff filed a suit on 2002. After a gap of 10 years, which also creates doubt in the mind of this court that the agreement to sell dated 1992 is a fake document. So the initial agreement of 1992 is adjudicated fake by the Honorable High Court and is giving no right to the appellant for the relief of specific performance. Even otherwise, the documents placed on records by producing the electricity copy of judgment of the initial annexure P, this is annexure P, which was adjudicated ex parte in favor of the petitioner number 1, in favor of plaintiff petitioner in the present case, does not support the claim of the appellant. Because that case was delivered ex parte, it has no value upon this court to adjudicate on basis of that. It shows that she was never in the possession of the property in question. So after taking this, the present appeal is allowed and devoid of merits. So challenging this judgment of Honorable High Court, the petitioner, which was initially plaintiff in the original suit, have come to the Supreme Court. And on what grounds have she come to the Supreme Court? We'll go through the, first we'll see what is the question of law in the present case, then we'll see the grounds. So question of law which has been framed is whether discretion in case of specific performance ought to be used judicially. The second question of law is whether when the execution of agreement to sale is proved and is held that respondent number 2 is authorized to execute the agreement in such case, such agreement can be held as fake document just because respondent number 1 did not receive any anyway. So this argument they have taken because the initial suit was ex parte delivered in the favor of petitioner number 1 और plaintiff, कि अब इस बेसिस पे हाई कोर्ट डिसाइड कर सकता है कि वो कभी पोजेशन में नहीं था, क्योंकि एक्स पार्टे सूट में कह दिया था कि वो पोजेशन में है. नाउ द ग्राउंड्स, सो यू डोंट हैव टू राइट, कमिंग ऑन टू द ग्राउंड्स, यू डोंट हैव टू राइट ऑल द ग्राउंड्स. you only have to write the grounds which are important to adjudicate before the Supreme Court. So the first ground is because High Court has erred in not appreciating that all courts had held that defendant number two, respondent number two has power authority to execute the agreement to sale or sell dispute property. Because High Court has erred in not appreciating that agreement to sell dated has been proved by the petitioner by examining a testing witness. Further, it has been held that the agreement to sell is valid. So the first ground, the most important ground they are relying upon is the initial judgment, which was adjudicated ex parte, which held that the agreement is a valid agreement. So main ground is this one कि initially civil court ने कह दिया था कि agreement is valid. Now High Court cannot say that agreement is not valid क्योंकि trial वहां पे चला था. तो because High Court has erred in not appreciating that petitioner is in possession, first they are saying that they were in possession and the petitioner also had paid sale consideration to respondent number two and hence he is entitled for decree of specific performance. So these are the main grounds. Sorry everyone, I'm rushing because I'm in the office right now. तो थोड़ा जल्दी बता रहा हूँ, सर आने वाले होंगे. तो हाँ, the first part is this only. बाकी Romit, if you want to add something.
Yes, one more thing कि बस जब तुम लोग ग्राउंड्स कर रहे होगे ना, मेक श्योर टू रिमेंबर कि सुप्रीम कोर्ट इज नॉट अ फैक्ट फाइंडिंग अथॉरिटी. इट्स नॉट अ कोर्ट जहाँ पे एविडेंस हैज टू बी रीअप्रिशिएटेड. सुप्रीम कोर्ट इज ओनली देयर टू अप्रिशिएट द लॉ वेदर लॉ में कुछ गलत हुआ है नहीं हुआ. नाउ दैट ग्राउंड जिसके अंदर बोला गया था कि वन अटेस्टिंग विटनेस का एविडेंस कंसिडर नहीं किया गया है. इफ दैट एविडेंस क्या कहते हैं, यू कैन नॉट से कि उस अटेस्टिंग एविडेंस उस अटेस्टिंग विटनेस का एविडेंस वुड बी रेलेवेंट because उसका appreciation is technically not a fact finding appreciation. But if there is another ground which is bringing some remote evidence which it did not bring in either before the appellate court in first appeal or before the trial court, that you cannot do it in Supreme Court. So make sure to remember Supreme Court में नए evidence या कोई और ऐसे evidence जो पहले consider नहीं किया उसको नहीं आ सकते. Degree of appreciation is a question of law, but appreciation of a new evidence or appreciation of evidence in different light is fact finding, and that cannot be done in Supreme Court.
So now I'll share the brief that I've made of this last year question paper. तो तुम्हें आइडिया हो जाएगा कि मैंने एक सिंगल ब्रीफ में उसको कैसे बना दिया. So this is our case जिसका मैंने अभी तुम्हें क्वेश्चन पेपर दिखाया आप सबको. So this is SLP number. This is Shanti versus Satya, the parties before the Supreme Court, the cause title before the Supreme Court. It is against coming from the impugned order of Punjab and Haryana High Court dated 19/1/2018, wherein regular second appeal was dismissed, which was preferred by the petitioner against the first appellate court order, which overruled the trial court judgment. This is the brief case history which you will have to write, कि आप एक आइडिया हो जाएगा कि कहाँ से एक केस सुप्रीम कोर्ट पहुंचा है. हाई कोर्ट in impugn held the document produced by the petitioner of the sale agreement was a fake document. ये basic idea हो जाएगा whoever is reading this case brief कि हाई कोर्ट ने adjudicate किया. So these are the brief facts. 1992 agreement to sale executed between petitioner to respondent. So I have added this also: petitioner, plaintiff, respondent 1, defendant 1, through his power, respondent 2, defendant 2, of disputed property of sale consideration this much. Petitioner contends total consideration was paid and possession was transferred. Now in 1997 D1. So I'm using abbreviation कि case brief छोटा बने. D1 is defendant 1, respondent number is R1 is respondent number 1 through GPA. D2 D2 R2 sold away disputed property to defendant number 3 and respondent number 3. In 1997, petitioner filed civil suit number this much before civil judge against D2 and D3 and Om Prakash. So Om Prakash in case brief was not a respondent number 3, जो मेरे को बाद में पता लगा. He was only a friend of respondent number 3, which was interfering in the possession of the petitioner. That's why he was also implicated for a permanent injunction. So D3 is the person to whom in 1997 the property was sold. Now, civil judge decreed civil suit ex parte and held oral and documentary evidence. The petitioner has proved that she is the owner of possession of the property in dispute, and defendants are restrained from interfering with the possession. So this is annexure P1. You'll have to write key if the person who is reading the case brief wants to go through the original document, he can go through it कि annexure P1 पे. यहाँ पे मैंने पेज नहीं लिखा है क्योंकि पेज में differ. Usually you also write the page number. So page number can differ. That's why I have not written page number. Now, in 2002, petitioner filed civil suit, this one, before additional judge, for specific performance and on the basis of agreement to sell, and further declaring registry dated the second agreement null and void. The additional judge adjudicates upon this, and 2 civil appeals are filed against the judgment of additional civil judge, which is adjudicated in favor of respondent in the present case. So, petitioner, plaintiff files a regular second appeal before the High Court. So these are the reasoning in the impugn. जो impugn में मैंने बताया था आपको कि agreement to 1992 is a fake document. You'll also have to write para here. Para मैंने नहीं लिखा है कि क्योंकि change हो सकता है. यहाँ पे para लिख दो. If the person wants to cross reference यहाँ लिख सकते हैं. This is the ratio. This is the reasoning, giving which the High Court has adjudicated the issue. Now I have written 3 grounds. Ground 1. The possession of disputed property has been transferred to the petitioner. Learned civil judge has held the agreement to sell dated is a valid document, and consideration has been paid by the petitioner. So this is the brief. A person who is reading this will get an idea of what is the case is about, the case history, and the relevant consideration which Supreme Court has to take to consider to adjudicate the matter. So this is the question number 1. Yeah.
Just one more thing. So guys, जब तुम लोग ब्रीफ वाले क्वेश्चन अटेम्प्ट करोगे, देयर आर 2 more things जो तुम्हें ऐड करना होगा. एक तो इफ़ यू गो इनटू द लाइक पेपर के एकदम स्टार्टिंग में ना, आरिफ आई मीन लाइक इफ़ यू कैन शो द मॉक पेपर, ना मैं शेयर स्क्रीन कर देता हूँ अबाउट दैट डिले वाला पार्ट. या अगर क्रिमिनल मैटर हुआ तो सेंटेंस अंडरगॉन, देन ऑफ कोर्स अगर इंटरिम रिलीफ सीख कर रहे हैं देन दैट पार्ट. वरना मैं शेयर स्क्रीन शेयर कर देता हूँ.
नहीं मैं कर देता हूँ.
ठीक है. सो यूजुअली व्हाट हैपेंस इज लाइक फॉर सुप्रीम कोर्ट, अगर मैटर को फाइल करने में कुछ डिले हुआ होगा या फिर अगर कोई क्रिमिनल मैटर है तो अगर पर्सन बहुत ज़्यादा लॉन्ग इनकार्सरेशन में रह चुका है तो दीज आर ऑल रेलेवेंट फैक्टर्स दैट हैव टू बी रिटन इन द वेरी टॉप. बिसाइड्स दैट अगर कोई भी एसएलपी के थ्रू कोई इंटरिम रिलीफ सीख कर रहा है, दैट नेचर ऑफ इंटरिम रिलीफ व्हाट ही इज सीकिंग बिसाइड्स द मेन रिलीफ, क्योंकि मेन रिलीफ ऑब्वियस होता है कि भाई अलाउ द एसएलपी सेट असाइड द इम्प्यूग्ड ऑर्डर, बट इंटरिम रिलीफ डिफर्स. सो लाइक वो लिखना जरूरी होता है. सो इन दिस केस यू कैन सी इंटरिम रिलीफ इज स्टे ऑफ द ऑपरेशन ऑफ द इम्प्यूग्ड जजमेंट ड्यूरिंग द पेंडेंसी ऑफ द अपील या फिर ड्यूरिंग द टिल द डिस्पोजल ऑफ दिस मैटर. सो ये तुम लास्ट में लिख देना आफ्टर यू डन विद द ग्राउंड्स, राइट, कि व्हाट आर द इंटरिम रिलीफ दे आर सीकिंग. डिसाइड्स दैट एकदम स्टार्टिंग में यूल गो. सो जो भी एसएलपी का फॉर्मेट होता है, एसएलपी बिगिंस विद ऑफिस रिपोर्ट, लिस्टिंग प्रोफार्मा, सिनॉप्सिस, केस के बारे में बताते हैं, लिस्ट ऑफ डेट्स जो जितना भी फैक्ट्स इवेंट्स है, देन मेन एसएलपी शुरू. तो उधर लिस्टिंग परफॉर्मा में भी ना तुम्हें डेट्स और ये सब देते हैं, है या क्या यहाँ पे?
बट इन आवर क्वेश्चन दे हैव नॉट एडेड द लिस्टिंग परफॉर्मा.
अच्छा, लिस्टिंग
दे
परफॉर्मा
स्टार्टेड विद द लिस्ट ऑफ डेट्स. हां,
ऑफिस जो रिपोर्ट था आई थिंक सो.
कॉन्डिनेशन ऑफ डिले था, ऑफिस रिपोर्ट भी नहीं था, हमारे क्वेश्चन पेपर में नहीं था.
मैं एक बार चेक.
लिस्टिंग परफॉर्मा हैज बीन एडेड टू सैंपल पेपर्स दिस ईयर.
करेक्ट.
सैंपल पेपर्स में आई विल शो यू. दिस इज सैंपल पेपर.
नहीं ऑफिस रिपोर्ट एंड लिस्टिंग परफॉर्मा है क्वेश्चन पेपर में.
हां, सैंपल पेपर.
हां, नो क्वेश्चन 2 में मैं दिखाता हूँ एक बार, मैं स्क्रीन शेयर कर देता हूँ. हाउ डू यू शेयर दिस? तब तक सत्यम आई थिंक सब अगर कुछ मिस किए हम दोनों तो बता दे भाई, लास्ट मोमेंट तक मत कर. सो लाइक आई थिंक सो यू विल बी एबल टू सी पार्ट 2 वाला क्वेश्चन. तो यही जो शांति वाला केस था, ठीक है, इसके अंदर यूल सी ऑफिस रिपोर्ट तुम्हारा आ जाता है. ऑफिस रिपोर्ट बता देते हैं एक तो पिटिशन लिमिटेशन के विद इन है, बट पिटिशन रीफाइलिंग में कोई डिले हुआ था. सो देयर इज अ डिले इन filing, there is a delay of 525 days in refiling. So what usually happens is कि you have 90 days of limitation period of filing an SLP to challenge an order. तो जिस दिन मान लो अगर 1 अप्रैल को क्या कहते हैं ऑर्डर प्रोनाउंस हुआ हाई कोर्ट का, देन यू हैव 1 अप्रैल से 90 डेज टू फाइल एन SLP. अगर उसमें कुछ डिले होता है दैट इज डिले इन फाइलिंग. 90 डेज SLP फाइल करने के बाद भी देयर आर सर्टेन प्रोसीजरल रिक्वायरमेंट्स लाइक क्लियरिंग डिफेक्ट्स एंड ये सब जो यू हैव टू डू. उसके बाद तुम्हारा मैटर इज कंसिडर्ड एज रीफाइल्ड एंड वेरीफाइड. अब वो रीफाइलिंग में जितना डिले है यू विल हैव टू मेंशन दैट 525 डेज. यू कैन अगर कुछ इसके अंदर डिले है, देन यू कैन गो थ्रू द इवन द एप्लीकेशन ऑफ कंडोनेशन डिले टू, बहुत छोटे में यू हैव टू टेल कि भाई क्या रीज़न था कि ये डिले हुआ था या नहीं हुआ था. सेम लिस्टिंग परफॉर्मर गिव्स यू कि कोई सिमिलर मैटर पेंडिंग है नहीं है. अगर पेंडिंग है तो यू हैव टू राइट इट इन द टॉप कि ये मैटर पेंडिंग है या नहीं है. ठीक है. बिसाइड्स दिस यहाँ पे ही वो भी होता है, क्या कहते हैं, वेदर अक्यूज कन्विक्ट हैज सरेंडर और नॉट, और यहीं पे सेंटेंस अवॉर्डेड एंड सेंटेंस अंडरगॉन. ठीक है, इंक्लूडिंग पीरियड ऑफ डिटेंशन कस्टडी. अगर क्रिमिनल मैटर है, दिस इज वेरी इंपॉर्टेंट, मेक श्योर टू मेंशन कि सेंटेंस कितना अंडरगॉन हुआ है. आरिफ, यू वांट टू टेक द रिसर्च मेमो वाला भी?
नहीं, सत्यम would like to start.
सत्यम प्लीज टेक द रिसर्च मेमो. सत्यम है क्या? जब तक सत्यम आता है तब तक फिर मैं बस यही बता देता हूँ, लाइक हाउ डू यू लाइक अटेम्प्ट दिस. सो लाइक तुम्हारा मोस्ट प्रॉब्ली ऐसे तो इस साल सुप्रीम कोर्ट ब्रॉट अ न्यू नोटिफिकेशन सेइंग दैट वाज पर्टेनिंग टू AOR एग्जाम, बट AOR एग्जाम दे वर कंडक्टिंग कंप्यूटराइज्ड. ठीक है, दे वर टेकिंग डेस्क डेमोस की कंप्यूटराइज्ड AOR एग्जाम लेने का ट्राई करते. तो बहुत स्लिम चांसेस है, बट हल्का से 1-2% चांस है कि तुम्हारा एग्जाम भी कंप्यूटराइज्ड हो, एटलीस्ट MCQ वाला. अगर वो होता है दैट इज वेल एंड गुड. MCQs कंप्यूटराइज इज फार मोर ईजियर दैन OMR शीट में सर्कल करते रहना. बट तुम्हारा पार्ट 2 मोस्ट प्रॉब्ली पेन पेपर मोड में ही होगा. उसके लिए आई वुड सजेस्ट, लाइक इफ यू वांट टू, लाइक दिस इज हाउ आई यूज टू मेक द ब्रीफ्स, लाइक फॉर पर्पज ऑफ प्रैक्टिसिंग. ब्लैक से जितने भी हेडिंग्स आ गए सब कुछ पॉइंट वाइज करता था. यू कैन सी लाइक डैश 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 में पॉइंट वाइज है. ब्लू में क्या कहते हैं मेन स्टफ लिखता था, और जो भी ब्लैक से क्या कहते हैं ग्राउंड ये है, ये पैरा 18 किसका, इम्प्यून ऑर्डर का पैरा 18 क्या है, ये यू कैन राइट लाइक दिस. ठीक है, सब पॉइंट का भी सब पॉइंट यू कैन मेक फॉर मोर नीटनेस. ठीक है, एंड आई टेंड टू रेफर टू, ये लाइक सबका पर्सनल स्टाइल होता है, आई टेंड टू रेफर टू एज रिस्पॉन्डेंट इंस्टेड ऑफ राइटिंग एंटायर रिस्पॉन्डेंट आई जस्ट राइट R2. पिटिशनर की जगह आई जस्ट राइट P. ठीक है, दिस इज जस्ट अ वे ऑफ दैट यू कैन राइट जितने भी जजमेंट्स आर रिलाइंग, यू कैन राइट इट इन ब्लैक. Usually this is how we make briefs. ठीक है, so in this so you can see like P dates अलग कलर में है. ठीक है, और क्या कहते हैं R रिस्पॉन्डेंट का यहाँ पे आएगा. सब्सिक्वेंट डेवलपमेंट्स कुछ है, अगर रिट पिटिशन के आने के बाद पेंडेंसी में यू कैन राइट दैट. प्रेयर में भी यू कैन राइट स्टफ. एंड ये इंपॉर्टेंट है, जो भी तुम मैटर शुरू करो ना, जस्ट राइट आइटम और डैश छोड़ देना. तुम्हारे क्वेश्चन में तुम्हें पता नहीं होगा ये आइटम नंबर क्या है, बट आइटम नंबर बेसिकली सिग्निफाइज कि ये कब मैटर टेकअप होगा जज के पास. तो आइटम के बाद तुम बस डैश छोड़ देना. दैट बेसिकली गिव्स अ सेंस कि यू नो हाउ सुप्रीम कोर्ट वर्क्स. ठीक है, एंड लाइक ऑफ कोर्स यू नीड टू मेंशन लास्ट में कि कौन सा नेक्स्ट कौन से पेज पे, दिस काइंड ऑफ, जो आरिफ ने बहुत डिटेल में ऑलरेडी बता दिया है. सत्यम है क्या?
Yes, yes, I am here, bro.
Please,
I'll
go ahead.
just show one brief, and I'll quickly walk you through as how to save some time while you're actually attempting the paper. So just give me 10 seconds. I'll share my screen. I can.
Yeah, Susan.
Hey Romit, actually I had a question for you. So what sources did you use when you were practicing while drafting these briefs?
So well, while I was preparing for this exam, I was already working in some office, so I had huge volume of access to various SLPs and ESA. ठीक है, तो that is how I used to go ahead and practice. we'll discuss amongst ourselves कि अगर हम तुम्हें कोई practice questions दे सकते हैं SLP या ये सकते या नहीं. ठीक है, that again of course parties के files है, we can't give that like that. ठीक है.
Romit, is my screen visible?
Yeah, it's visible and your audio is also clear, bro.
Thank you. Okay. So these cases that you can get for briefing, one is a category 5.
I think so, bro. तेरे network में कुछ problem है.
Particular.
Yeah, Satyam. So anyway, जब तक सत्यम आता है मैं लाइक यही बोलूँगा, लाइक जितना भी इफ़ यू कैन प्रैक्टिस पेन पेपर मोड में. ठीक है, ब्लू ब्लैक पेन रखो, प्रैक्टिस करो, सो दैट योर राइटिंग स्पीड इम्प्रूव्स. ठीक है, दैट वाज द बिगेस्ट डिफिकल्टी दैट आई हैड. लाइक आई वाज नेवर यूज्ड टू राइटिंग पेन पेपर्स, स्पेशली ड्यू टू कोविड. हेलो सत्यम. सो अगेन सत्यम के ब्रीफ में भी एक लाइक बहुत ही इंपॉर्टेंट चीज़ है जो लाइक मैं भूल गया था बताना. आई जस्ट कम टू यू मयूर. या आई ऐसे मैंने स्टार्टिंग में जनरल अवेयरनेस वाला कर दिया था बट आई अगेन तुम लोग रिकॉर्डिंग देख सकते हो. बट इन एनी केस यूल सी यहाँ पे प्रीवियस ऑर्डर्स लिखा हुआ है लाइक जस्ट आफ्टर क्या कहते हैं डिसमिस डिस्पोज एंड पेंडिंग. सो लाइक सिमिलर मैटर्स एंड प्रीवियस ऑर्डर्स आर ऑल्सो इंपॉर्टेंट. हमारे टाइम पे ये आया नहीं था बट आ सकता है. अगर आया है तो कोई भी अगर इंपॉर्टेंट प्रीवियस ऑर्डर लेट से प्रीवियस ऑर्डर में कोई रिलीफ ग्रांट कर दिया होगा या प्रीवियस ऑर्डर में कुछ डायरेक्ट किया होगा कि नेक्स्ट ईयरिंग तक तुम्हें ये करना है, नेक्स्ट ईयरिंग तक कोई काउंटर फाइल करना है या एडिशनल डॉक्यूमेंट्स फाइल करना है. These are also very important to mention. एकदम स्टार्टिंग में आता है. एंड लाइक आरिफ एंड मी प्रीवियसली टोल्ड सिमिलर मैटर्स अगर कोई थे पेंडिंग है डिस्पोज हुए क्या हुआ है यू विल ऑल्सो हैव टू मेंशन ऑल ऑफ दिस. ये सारे यू विल फाइंड इन द लिस्टिंग परफॉर्मर. एंड लिस्टिंग परफॉर्मर के बाद देर इज अनदर सेक्शन नोन एज ROPs और रिकॉर्ड ऑफ प्रोसीडिंग्स. रिकॉर्ड ऑफ प्रोसीडिंग्स या तो स्टार्टिंग में होगा या फिर यूजली एंड में होगा. तो यू विल हैव टू अगेन सी कि इस मैटर में क्या रिकॉर्ड ऑफ प्रोसीडिंग्स फॉर द SLP में क्या क्या हुआ है अभी तक. सी रेलेवेंट PDF ऑफ द प्रीवियस पेपर्स तो ऑलरेडी क्या कहते हैं सुप्रीम कोर्ट के साइड पे है बट लाइक जैसे मैंने स्टार्टिंग में बताया था वो सारे इतने अब रेलेवेंट है नहीं. दी पैटर्न हैज़ कम्प्लीटली चेंज्ड. ठीक है. जो सबसे लास्ट वाला एग्जाम पेपर था जो हमने दिया था दैट इज़ द न्यू पैटर्न नाउ. आई हैव एक्सप्लेन एकदम स्टार्टिंग में. यू कैन गो हैड एंड वॉच इट इन द क्या कहते हैं रिकॉर्डिंग. होपफुली वील मेक द रिकॉर्डिंग अवेलेबल. एंड इवन अदरवाइज किसी को भी कोई डाउट है यू कैन approach us like session खत्म भी हो जाए तब भी we are here. You can approach me, Arif, Satyam, anyone. We'll be there to help you. There is no problem at all. ठीक है. And Mayur, you had a doubt. Please go ahead. I'm sorry.
Yeah, am I audible?
Yeah.
Yeah. So in the PDF, it was written that the brief or the research memo should not be more than 2 sides.
Yes.
So we should stick to the point, or we can exceed the pages.
मैं तो मना करूँगा पेजेस एक्सीड करने से. ठीक है. स्टिक टू द पॉइंट. मेरे केस में लाइक व्हेन आई वाज मेकिंग द ब्रीफ वाला क्वेश्चन जब मैं एक्चुअल पेपर के टाइम में अटेम्प्ट कर रहा था आई मेड द ब्रीफ क्वेश्चन 3 बार. एक बार बनाया टू अंडरस्टैंड कि मैंने क्या क्या बनाया, देन उसको और शॉर्टन किया, दोबारा नीटली बनाया, फिर दोबारा काट के और छोटा करके और फिर से लिखा मैंने. ठीक है. सो लाइक देयर इज़ नो प्रॉब्लम इन डूइंग मल्टीपल अटेम्प्ट्स ड्यूरिंग द एग्जाम ओनली. जस्ट बी माइंडफुल जो आरिफ ने कहा था कि टाइम बहुत ज़रूरी होता है. ठीक है. एंड नंबर 2 क्या कहने वाला था मैं. राइट. अगर बहुत ज़रूरी है लाइक इफ इट्स अ ह्यूज मैटर तभी तुम पेजेस एक्सीड करो. बट ब्रीफ में तो आई विल ऑलवेज से नेवर एक्सीड द पेजेस. रिसर्च मेमो में यू कैन स्टिल एक्सीड द पेजेस. आई एक्सीडेड द पेजेस इन रिसर्च मेमो बट नेवर एक्सीडेड ड्यूरिंग द अटेम्प्ट फॉर ब्रीफ. ठीक है.
If you are crossing the papers, I mean, when we are writing something, and I thought that it is not right thing, or it is not a right answer, then I can cross it, right?
Yeah, you can
But-
cross it. I did that. मैंने करा.
But it is going to decrease my mark, right? Because it will not look good on
This is
paper,
what
so-
I also thought. So end में फ़र्क पड़ा नहीं. I also got in. ठीक है. So
Okay.
इट अगेन डिपेंड्स अपॉन कौन तुम्हारा एग्जाम चेक कर रहा है. दिस इज़ वेरी क्या बोलूँ मैं, दिस वेरीज. ठीक है. मेरे हिसाब से तो मैंने क्या कहते हैं कट वट करा था. ठीक है. बट आइडियली भाई आइडियल सिचुएशन ये होगा कि तुम्हें कट करने की ज़रूरत भी ना पड़े, तुम प्रैक्टिस इतना कर लो. बट यू कैन ऑब्वियसली डू दैट.
Okay. And one more thing, last thing.
Yeah.
Could you please share the brief, that's the sample brief or a research memo, so that we can get the idea of the structure, so that we can practice accordingly.
वो सब तो हम लोग शेयर करने का मोस्ट प्रॉब्ली सब कुछ ट्राई करेंगे जितना भी लाइक वी कैन शेयर विच इज़ नॉट कॉन्फिडेंशियल वील डू दैट. ठीक है.
On LinkedIn, right? Or you are going creating another group or something like that.
सी आइडियली तुम लोगों को अपने लिए अपने पर्पसेस के लिए एक ग्रुप बना लेना चाहिए. ठीक है. लाइक आई थिंक सो इफ वन ऑफ यू कैन जस्ट फ्लोट अ व्हाट्सएप क्या कहते हैं लिंक यहाँ पे, यू गाइस कैन टुगेदर प्रिपेयर, दैट वुड बी बेस्ट. बाकी माय प्लान वॉइस कि मैं लिंक्डइन पोस्ट को अपडेट कर दूँ इन द कमेंट सेक्शन ओनली. आई जस्ट पुट अ G ड्राइव लिंक जहाँ पे तुम सब एक्सेस कर पाओ. ठीक है. दिस इज हाउ आई एम प्लानिंग.
Yeah, please do it.
या.
Thank you.
एंड लिखिता यू हैड अ डाउट.
Yes, sir. Romit sir, I had a doubt that for paper 2, did you had any time management strategy कि इस क्वेश्चन के लिए इतना टाइम मैं दूंगा, ऐसे कुछ आपने प्लान करके गए थे कि?
मैं प्लान करके गया था जब एग्ज़ाम देने गया, कुछ भी प्लान के अकॉर्डिंग हुआ नहीं. मैं खुद बता रहा हूँ मैंने 3 बार ब्रीफ वाला अटैम्प्ट करा क्योंकि आई थॉट आई कुड डू दिस मच बेटर. तो इससे मैं कट करते रहता है। एंड जब रिसर्च मेमो का बारी आया, आई डिड नॉट हैव एनी टाइम, एक शॉट में आई हैड टू अटेम्प्ट इट। सो और प्लस तुम्हारे में एक तीसरा क्वेश्चन भी ऐड हो चुका है विच इज़ सिनोनिमस टू हाउ यू राइट अ मेंस के पेपर के अंदर आंसर की तुमसे कुछ भी क्वेश्चन पूछेंगे। सो सत्यम 1 मिनट में ज्वाइन कर रहा है, बट इन एनी केस, सो आई मीन लाइक yes, make time management plans, but by it doesn't work out unless and until तुमने प्रैक्टिस कर रखा है। प्रैक्टिस पहले कर लो, टाइम मैनेजमेंट अपने आप हो जाता है इफ़ यू ऑलरेडी यूज टू हाउ टू डू दिस। या प्रियांश?
Yeah, so I had a like doubt. For example, like when you clear the written examination and you go to the interview, so obviously do interning under a Supreme Court judge in your past gives a different effect in terms of interview? Would that help in clearing an interview, like interning under a Supreme Court judge? Yeah.
बाकी लाइक इंटरव्यू का आई वोंट गो इनटू दिस इन दिस क्या कहते हैं सेशन। इंटरव्यू का जब क्लियर कर लो मैसेज कर लेना, आई विल गाइड यू लाइक प्रॉपरली इंटरव्यू में कैसे क्या करना है, हाउ टू गो अबाउट क्या कहते हैं, इवन एक्सरसाइजिंग योर प्रेफरेंस लिस्ट, जो तुम्हें प्रेफरेंस लिस्ट मिलता है कि किस जजेस के साथ तुम्हें काम करना है, दैट्स बात का बात। अभी इंटरव्यू पे मत सोचो, इंटरव्यू बहुत बाद में आता है। एंड आई रिमेंबर एक क्वेश्चन आया था किसी का कि डू वी नीड मिनिमम ऑफ 50% इन MCQs। देखो मिनिमम ऑफ 50% इज़ द लोएस्ट बार कि तुम्हें MCQ में मिनिमम 50% चाहिए। 50% के बियॉन्ड भी तुम्हें चाहिए होगा जस्ट टू इवन बी इन अ पोजीशन कि तुम लोग क्या कहते हैं एग्जाम क्या कहते हैं मतलब तुम जजेस के साथ प्लेस भी हो जाओ या रजिस्ट्री में भी प्लेस हो जाओ। आई नो डैट मेरे आई स्कोर्ड MCQs में अराउंड 88, ठीक है, आउट ऑफ 100। एंड तब जाके इट वॉज क्वाइट डिफिकल्ट टू इवन गेट एन इंटरव्यू एंड क्या कहते हैं देन गेट सेलेक्टेड, ठीक है। सो लाइक 50% वाला बार के बारे में मत सोचो, थिंक कि तुम्हें MCQ में सबसे ज़्यादा लेके आने, ठीक है। एंड
so I basically
just
asked
one
that
second.
question
I
of
think so I'm getting Satyam ka call. Just one second. Yeah. Sorry.
So I basically asked that question of interning under Supreme Court judge or a High Court judge. Basically, like so for example, I'm in between of my 4th year. So the prospect of me interning under a Supreme Court or a High Court judge now in the coming 1 year, so would that increase my chances of clearing an interview subsequently when I appear for the law clerk research examination?
Yes, it will. Like again मैं कह रहा हूँ इंटरव्यू इज़ नॉट द मेन थिंग फोकस ऑफ दिस सेशन, बट मैं लाइक बहुत क्विकली बता देता हूँ। इन द एंड जजेस आर लुकिंग अपने इंटरव्यू प्रोसेस में कि हु कैन ऐड मोर वैल्यू टू देयर ऑफिस, हु कैन गेट द वर्क डन, एंड जजेस को उतना ज़्यादा रिलाई नहीं करना पड़ा। द मोर एक्सपीरियंस यू हैव द बेटर यू आर एबल टू डू इट। आई रिमेंबर मैं जब इंटरव्यू में गया था, आई हैड जस्ट ग्रेजुएटेड इन जुलाई 2023 ओनली। मेरा इंटरव्यू जुलाई 15, 2023 को हुआ था। द वन क्वेश्चन दैट द जज आस्क्ड मी ऑल द टाइम वाज कि wouldn't it be better that you go ahead and work for some advocate for 2 years instead of joining over here? You learn more over there. How will you be able to add value to it? Now the only point that came in rescue for me was that because previously जब कोविड का टाइम चल रहा था, I had been interning with advocate and I had learned कि सुप्रीम कोर्ट के अंदर कैसे ड्राफ्टिंग एंड ये सब होता है, and that is how क्या कहते हैं I was able to get into the interview because like मेरे से पहले there were few, मेरा रैंक से भी ऊपर वाले कुछ रैंक वाले इंटरव्यू पे आए थे, बट स्टिल एंड देयर वाज ओनली वन वैकेंसी इन माय जजेस ऑफिस, येट ही चोज मी बिकॉज ऑफ दिस, बिकॉज आई हैड प्रायर एक्सपीरियंस. Likewise with Satyam also, he had also interned with various judges and that is why he was selected in our office. So experience बिल्कुल देखा जाता है, nobody discounts that, everybody values that. ठीक है. And by the way सत्यम आने वाला होगा, तब तक थोड़ा बहुत और ब्रीफ्स का ही देख लेते क्या फर्क पड़ता है. It will help you only. And we can even go for research memo और ये सब का. See research memo पे I'll try to explain थोड़ा बहुत. Like research memo का I had not practiced, very honestly telling you, क्योंकि research memo is something like it varies. ठीक है. There is no strict formula or format also for that matter. तो जो तुम्हें research memo में क्या कहते हैं format दे रखा है ना, क्या कहते हैं यहाँ पे sample guide में इसी में था ना, आई थिंक सो, जो भी तुम्हारे सैम्पल गाइड में फॉर्मेट दे रखा है ना रिसर्च मेमोरेंडम का, ये वाला ऑन मेंटेनेबिलिटी, ये सब फॉलो दिस ओनली. वन एडवाइस दैट आई वुड गिव, इंस्टेड ऑफ राइटिंग दिस एंटायर पैरा, इसको भी तुम पॉइंट वाइज लिखो. लाइक आई टोल्ड यू ब्रीफिंग वाले में भी ब्लू ब्लैक पेन का इस्तेमाल करो, ब्लैक फॉर हेडिंग, ब्लू फॉर ये. एंड इससे बिफोर, सो रिसर्च मेमो में यू सी यहाँ पे क्वेश्चंस फ्रेम कर रखे. दिस इज व्हाट हैपेंस. जो तुम्हें रिसर्च मेमो देगा, जो लास्ट ईयर के पेपर में भी था ना, इसके अंदर रिसर्च मेमो में कोई क्वेश्चन नहीं दिया हुआ था. विल गेट बैक टू दिस. सत्यम आई थिंक सो वापस आ गए, एंड आई थिंक सो सत्यम विल बी. सत्यम,
Yes, bro. Can you hear me?
yes, all good.
Yeah, all good. It's just that the net has disappointed me today. No
ठीक है.
problem. Uh,
I'll stop presentation, you
I'll
can
just
go
share
ahead
my
and
screen. Yeah, I'll
yeah.
just share my screen. If it works, then it's fine. Otherwise, I'll let you know which files I'm going to talk about. So you can share those files. It's on the drive only.
या
ठीक है?
अच्छा, उस वाले मैं देखता हूँ. ठीक है,
तू ऐसा कर, तू ही शेयर कर दे.
मेरे को डाउनलोड
Open
करना
item
पड़ेगा.
number.
मैं
It's on
कौन
the
सा?
drive. It's on the drive.
अच्छा, मैं करता हूँ.
Item number 5, 19, and 22. 6th
5,
February.
1 second. Okay, 5, 19 and 22.
22, yes. 5 is the writ petition.
Yes.
So we can start with that.
मैं डाउनलोड कर रहा हूँ बस. In any case, तब तक you can go ahead and explain bro इनको.
So basically what I was telling is there are just three types of files that you need to be prepared with. And I would suggest that before you go to write the exam, practice at least 2 or 3 briefs from each category. So one is the writ petition, the other is the SLP, and the other is civil or criminal appeal. So ideally you should have practiced at least 10, 12 briefs before you write. Otherwise, because I'll tell you what happened to me. I had practiced around 70, 80 briefs because of my internship with a Supreme Court judge prior to my examination. But despite of that, there were certain portions which were so tricky in the brief on the exam day that it took me around 20, 30 minutes more than I had expected it to take me to. So the more you are practiced, the more confident you will be while attempting the paper, and the more helpful it is going to be. And how you're going to practice is definitely a question. So Romit, as Romit said, that Romit, Arif, and I would probably discuss with each other and see if we can share some files for your practice as a common resource material. We cannot guarantee you that because, of course, we are also bound by the privacy clauses and everything. So we'll see if there's a possibility of sharing some files.
And अगर कोई files हम share कर भी रहे होंगे, like this will be like old files, of course not
Yeah,
Supreme Court
yeah,
के files. Supreme Court के तो we can't. ठीक है.
true.
If like personal matters हमारे खुद के कोई भी है, तो we'll share that.
Yeah, and we'll probably sort of change the names or make them
Correct.
invisible.
We'll redact all of
From
those
the
elements.
yeah. Yeah.
Please Satyam, I
Can
share
you
it.
can you show the item number 5? So we have to do this within 1 hour because there are 3 questions that you have to attempt in part 2, and all 3 of them carry 100 marks. So ideally you should dedicate 1 hour, 1 hour 10 minutes to each question. So now let's see how you can increase your speed of drafting of briefing while you're going through the file itself. So for example, on the top you have to write the cause title of the matter. So item number, of course, you'll not know which item number it is, but as soon as you see the question paper, you can write this thing, Kamal Singh Javaria and others. So whatever the name of the SLP or the writ or the civil or criminal appeal before the court is, you quickly write that name on the answer sheet on which you are attempting the brief. So you don't have to go back. You don't do this that you take 20 minutes, read the file, and then go back and start writing, because there are some objective information that you have to write, and for which you do not need any application of mind, and this will save 5 to 10 minutes of yours. So instantly write item number this dash whatever the cost title is, whatever the number of the writ petition SLP is. So this does your cost title. Then you leave around 3 lines under that. So this is something that is totally optional. I do this because this is sort of a brief of a brief itself. So if let's suppose the judge is too short of time when he's going to the court the next day, then maybe he can just read the 2 lines under this, and he'll get an idea that okay, this is a service matter, or this is a criminal matter, this is a bail matter, and what is the main relief that they're seeking. So I do this. Some of us do not do it, so that's totally okay. If you prefer this style of briefing, then you can mention a short, crisp brief just at the top where the brief starts.
I
But you
would
can
also
only do
suggest कि
this,
तुम ये करो. This
yeah, and you can
helps.
only do this after you have finished the entire brief because only then you will know what the brief is. So you'll have to leave 3 or 4 lines in the beginning, and then you jump right to the next heading. Something which is very important is that you have to look at the office report which is mentioned, which is attached with the file. So if there is a similar matter which is pending, or if there is a similar matter which has been disposed, or if this same matter has come before the court and is barred by res judicata, it was dismissed previously and the petitioner has once again come before the court, you can get all of this information only if you look at the office report. So I'm not sure if they're going to attach the office report in the brief that they're going to give you in the examination. But if they do, it's generally at the last page or the second last page of the case file. So
Don't get
you refer to
confused.
it.
दो ऑफिस
Yeah,
रिपोर्ट होते हैं. स्टार्टिंग वाला ऑफिस रिपोर्ट लिमिटेशन होता है. सो गाइज वो
yeah,
स्टार्टिंग में
yeah.
रहते हैं. लास्ट वाला इज व्हाट सत्यम इज टॉकिंग अबाउट, मेन ऑफिस रिपोर्ट.
Yes, yes. So again, yeah, thank you, Romit, for pointing that out. So limitation is also something which is very important. So if the office report on limitation mentions that there has been a delay of X days, N days, then you mention that right at the top. So before you mention similar matters, write under item number 5, writ petition. Before this, you write delay, and you mention how many days it is delayed by. Because SLP jurisdiction is already a discretionary jurisdiction that the Supreme Court exercises. And if there is an unexplained delay in filing or refiling, then the court may not even want to go into the merits of the case and dismiss it at the beginning itself. So this is something that the judges generally look for, that if there is a delay, and if there is a delay, if it is unexplained, then it is very important to mention that there is a delay. And generally, if there is a delay, there will be an application for condonation of delay at the somewhere in the middle of the brief, right after the SLP or the writ petition ends.
सेम
So
विद
see if
सेंटेंस
there is,
अंडरगॉन. सत्यम एक बार वो भी
yeah,
बता दे.
same with sentence undergone in criminal matters. So if the accused or if the convict has been in jail for the last 15 years, 10 years, then you mention that right there. But this is of course only for criminal appeals and SLPs, criminal SLPs. Then you come to similar matters. For example, in this case, you'll see that there have been 5 matters which are similar to the current matter. 3 have been dismissed already or disposed, and 2 are pending. So the utility of mentioning this information is that when the matter comes before the bench, they can choose to simply tag it to club this matter with the matters which are already pending, so that 2 or 3 different benches are not going through similar matters and giving different opinions or wasting judicial time deciding the same issue. So this helps the judge that right when they take up the matter for hearing in the court, they'll say that, okay, this is a matter which is similar to a pending matter, so we're going to tag it with the matter which is pending before a different bench. Now, the next important is previous orders. And I'm not sure if they're going to give you files which are completely fresh in the question paper or the ones which have been taken up 2 or 3 times before by the Supreme Court itself. If there are any previous orders, then it becomes very important to mention 3 or 4 categories of previous orders. One is any previous order in which notice has been issued. So issuance of notice is one of the landmark steps that a SLP or a writ petition goes through in the Supreme Court. So you have to mention that in the previous order section. The other would be leave granted. So if any previous order mentions leave granted, then you have to mention that as well. If an interim stay has been granted by the court, then you also have to mention that. So I would say that for your purpose, these three are the most important categories of previous orders that you have to mention.
And direction.
One is notice issued, the other is leave granted. Yeah. And direction. So, Romit, yeah, which is the direction part I could not get? Can you please elaborate?
So like there will be often times कि petition last time लिखा था तो they'll just direct कि you place on record this document on the next before the next date of hearing, or you file the counter affidavit within 4 weeks before the next date of hearing. So these kind of directions लिखा होना चाहिए, क्योंकि when the judge is going through the brief, he'll see कि last time मैंने इसमें क्या बोला था, and then you will be able to see in the office report whether this has been complied or not. So let's say बोला गया था कि counter affidavit file करने के लिए लास्ट ऑर्डर में, यू कैन चेक द ऑफिस रिपोर्ट अगर दे रखा होगा लास्ट में ऑफिस रिपोर्ट पे कि वाज द काउंटर एक्चुअली फाइल्ड और नॉट, एंड देन यू कैन ऑब्वियसली मेंशन इट इन ब्रैकेट कि भाई काउंटर फाइल हुआ नहीं हुआ. सिमिलरली अदर डायरेक्शंस आल्सो कि कुछ भी दे सकते हैं. सो यू विल जस्ट हैव टू बी श्योर. मोस्ट प्रॉब्ली नहीं आना चाहिए ये सारे आरोपीज, बट फॉर योर ओन सेक हम वी आर ट्राइंग टू कम्प्लीटली डू ऑल द एस्पेक्ट्स जो भी है सब कुछ कवर करने का कोशिश कर रहे हैं हम लोग. सत्यम प्लीज, सॉरी, गो अहेड.
Yes, bro. Thank you. Romit, I'll also request you one thing that after we are done discussing this, just show them what an office report looks like.
या
Because I don't think it was there in the previous year question paper and it
नहीं
was
था,
not
नहीं
there.
था.
So just show them किसी भी. Yeah. So एक बार after we are done with this. Yes, after previous order. So I think this is the sequence. I think my briefs are uh, almost along the same lines with which you are required to do in the question paper. Because I practiced a lot for the exam back then. So you can follow this pattern, or if there is one or more, two more headings or columns that you have to mention, that you can include that as well. Then you straight away come to brief facts. So, as Arif very elaborately discussed already, I think the facts that you can rely on are the ones which have been admitted or which have been judicially acknowledged in the impugned order, or any judgment of a court which the matter was before. So, for example, if this is a criminal matter which started at the Sessions Court, then went to the High Court, and now it has come to the Supreme Court. So, the best judgment to take the facts from would be the judgment of the Sessions Court. And if you want to further filter it out, if you do not have a lot of time to go through the Sessions Court judgment, then you directly take it from the High Court judgment. But never take the list of date or the synopsis on the face value, because it is one-sided evidently. The SLP is filed by one party and they'll try to show every fact, only those facts which support them, and try to present it in a manner which only supports their cause and not the other side. So a more balanced understanding of the facts can be taken from the impugned judgment, either of the trial level or of the High Court appellate level. And one more thing, keep the facts concise. The idea of a brief is that the judge can save time, and if you are going to reproduce from the list of date or synopsis or anywhere else, then there's no point, because the judges can themselves go through the list of dates very quickly. It's hardly 7, 8 pages, 10 pages. So the idea is to rephrase it in a simple language and make it as concise as possible. Ideally, a brief should be one page, but if it goes to 2 pages, it should not exceed 2 pages in any case. Try to keep it as short as possible. Mention only those facts on which the issue before the Supreme Court pertains, and not any other irrelevant facts. And then grounds is something that there will be 10 or 20 grounds that every petition before the court contains. You do not have to mention 20 of them. Only 1, 2, or max 3, 4 would be the grounds which are actually substantive. Filter out those grounds and only mention them. So why I was showing you this brief was, this is a writ petition. In a writ petition, there is no impugned judgment that you can refer to. So in this case, of course, you have to be relying on the list of dates, synopsis, and the contents of the writ petition itself for taking out the facts and the ground. But this is not the case with an SLP or with the civil or criminal appeal. And most likely, you will not get a writ petition in the examination. I think you're only going to get a SLP, civil or criminal in the examination. Yes, Romit, can you show item number 22 or 19? Either of them.
Before that, just one more thing. एक चीज़ सत्यम ने बहुत बढ़िया करा हुआ है. He has not mentioned question of law. So like most of the time, if you'll come across SLP or writ petitions, question of law बहुत ही moot points होंगे जो like एकदम unnecessary and irrelevant है. Like they won't be question of law, बस for formality sake के लिए उन्होंने question of law डाल दिया होगा. It's not necessary कि तुम सारे question of law डालो. Just like it is not necessary तुम सारे grounds डालो. ठीक है, you will have to apply your own mind to see क्या relevant है क्या नहीं. I'll open item 19.
Yes, yes. Yes, so for example, in this, if you look at the previous order, the order dated 13 January 2023. This order is very important because firstly, notice was issued, and secondly, interim stay was granted on the relief which the appellant before the court is seeking. So this becomes a very important previous order to mention in the brief if it is given in the examination. Then you'll see the brief facts. We have to mention the page number and extra everything very specifically, because These are actual cases which our judge has to go through. So it is for his convenience. You can skip mentioning the PDF page and everything. You'll not know what the PDF page is. You can mention the annexure definitely. So I think this was a thoda sa tricky matter. So the brief facts have gone into 7, 8 lines. The impugned order, I think, if you can come to the impugned. So you'll see the difference. There was no impugned order in the writ petition,
Hello.
but since this is a civil appeal, there is going to be an impugned order. So you have to read the impugned order.
नहीं,
It can be, if you're
आप
lucky,
थोड़ी
it
देर
will
में आ
be a
जाएंगे
3 page order. If
15-20
you're
मिनट
unlucky,
में
it's going to be a 50 page order. So
हेलो
that's totally depends on your luck, what
15-20
kind of a
मिनट आ जाइए
brief you're going to get in the examination. And if you're taking facts from the impugned order, then mention them in the brief as column only. Do not mention them in the impugned order. So you'll see the first line of
कितना पे
impugned
करना
order.
है मेरे को
NCDRC took note of the
कितना
facts of
करना
the
है
matter from the affidavits filed by
261
the
एक
appellant.
काम करिए
The
ना
facts
आप
have been
आ
set
ही
out
जाइए
above.
मेरे घर पे कोई है
So
मैं
you just tell this that the facts as taken note of by NCDRC have been set out above. So it saves
हाँ
redundancy
हाँ
as well.
हाँ
The facts which NCDRC accepted and the facts which
हाँ
you're
हाँ
putting in this brief are the same, and it does two things. It
ठीक
hits two targets with one arrow. Uh, yeah.
हाँ
Then
सत्यम
grounds. I think in this case the grounds were important. Yes, yes, Romit.
you'll have to excuse me for 5 minutes I'll just have to duck out I'll just come ठीक है तब तक you can screen share also ठीक है तब तक मैं अभी के लिए ये खोल
Yes,
के
yes,
देता
no
हूँ
problem.
ठीक
Thanks for.
ऑलराइट थैंक्स यार
Ha ha ha. Okay, no problem. Yes. So if you go through the format of an SLP or a civil appeal, really the sequence is that there is a firstly there is a synopsis, then there is a list of dates, then after that the main content of the petition starts. So there is a memo of parties, then there are questions of, then there are grounds for grounds, then there is a prayer for interim relief, grounds for interim relief, and then there is the main prayer. So this is the structure that a SLP or a civil appeal generally follows. A writ petition is slightly different. It does not have the impugned order and everything. So you have to get very familiar with all of these, and you have to get certain extracts from all of these portions and put them in the brief. So if there is an interim prayer which is very important, then you'll have to mention that as well. For example, in this case, one of the interim relief which is very important and which will also affect whether which will impact whether this matter becomes infructuous even before it is taken up by the Supreme Court is that the official liquidator in this case has to be restrained from withdrawing the amount which is lying before the NCDRC. And let's suppose you do not mention this in the brief, then the judge will not know that there is a very pressing, urgent requirement for an interim prayer, which is also moved by the petitioner or the appellant. So also go through what the interim relief is. If it is substantive in nature, if you think it is something which is very urgent and which will also affect whether the matter becomes infructuous, then you'll have to mention it. For example, in this case, if the prayer for interim relief is not granted, let's suppose, and the official liquidator during the pendency of this matter moves the NCDRC and gets a favorable order which allows him to withdraw the amount which is deposited, then the main petition, main appeal which is filed before the Supreme Court would be rendered infructuous. So in this case, interim relief is very important. So you mention that in a small heading that there is a prayer for interim relief as well. So yeah, I was telling you how to save time as well. So for example, Romit, can you scroll thoda sa upar?
Yeah, one more thing to save time, like how Satyam has mentioned, R2, 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 this saves time and saves space also. तो like तुम्हारा brief छोटा दिखता है. Respondent 2 की जगह R2.
Yes, yes, yes. If you can write in a small handwriting, then that's great. You will get around 50, 60 more words to fill in the 2 pages. But I would suggest that see the first line of the brief facts. When I write respondent number for the first time, respondent number 1, in the bracket itself I write R1. So that if the person is reading my brief for the first time, he knows what R1 means right in the beginning. Again, as CPA, as Romit has highlighted, Consumer Protection Act, you mention in the bracket CPA. So everywhere you'll use this abbreviation in the brief, and this you tell in the very beginning to the person who's reading the brief. Because everyone might use different terms. I know people who write PET for petitioner and not P. and RESP for respondent and not R. So it's very important to tell in the beginning itself that you're going to use R or RESP or whatever abbreviation you like. Saving time thing. Yes, I think थोड़ा सा scroll करना wrong है ऊपर.
ऊपर.
Yes, yes, मतलब to the top.
Yeah.
Yes. So you you mentioned this the course title as soon as you see the question paper. You mention this. You open the brackets for the short description. You'll know instantly as soon as you look at the file that this is a match. This is an appeal or this is an SLP against which forum. So you mention against NCDRC, against Calcutta High Court, against Allahabad High Court, against NCLAT, whatever it is, and what date it is. So you mentioned this against NCLAT dated 10th January 2020 in what was the petition number or file number before the court impugned court. So you mention all of this and then you put a dash and then you leave 3 lines and then you come down. As soon as you are reading the file, go instantly to the previous orders if they are mentioned in the question paper that you get. You quickly write these things, previous orders, whatever previous orders you think are important, you mention that. Brief facts you'll not be able to write in the initial 15 minutes itself. So you do not attempt this. You can set out the grounds, the main prayer and everything, but I would suggest that you do not do this. You first take 10 minutes after mentioning all of these factual information to understand what the matter is. Spend 20 minutes to read the impugned judgment, to cross-check it with the list of dates and the annexures if they have been provided. And then you use a highlighter. So I took 2 highlighters, 2 different colors. One was to mark everything which was favoring the petitioners. One was to mark everything which was stated or favoring the respondents. So that when you are eventually attempting to write the brief, you can quickly see that, okay, this is green color, all of this is petitioner's portion. So you mention that in the first 3 lines of the brief facts. Then whatever are the grounds which were taken by the respondent before the court from which the challenge has come, then you mention that in the next 3 lines in the brief facts. So using highlighter is definitely going to save your time. Keep the brief very tidy. Mention everything which is factual in the beginning itself, and do not start attempting the brief facts and the impugned portions before you have understood it fully, because then you end up cutting certain paragraphs which reflects very badly on you. You're also going to lose space. So the brief which is supposed to be finished in 2 pages will exceed the limit of 2 pages and go into 2.5 or 3 pages, which is definitely by which you'll definitely lose marks. So be very mindful that you write only when you're sure what the facts are and what the grounds are. These factual information you write in the beginning itself. I think that's it from my side. If there are any questions that you want to tell or you want to ask, please let me know.
I don't think so किसी का है अभी questions.
Yeah, can you explain again when we have to write or mention prayer and when not to?
Bro, so most of the cases में बहुत ही क्या बोलेंगे rote prayer होती है कि allowed grant leave to appeal against this, grant leave to file the SLP, ऐसा कुछ होता है. So it is very irrelevant to write, because SLP file करने का objective ही यही है कि you want that the court grants leave to the petition that you filed. So you do not mention that. The only prayer which is important is interim relief वाला prayer, because उसमें ही कुछ substantive you can ask even before the matter comes up before the court. In an SLP you cannot put a prayer कि मुझे yes Romit.
नहीं please go ahead, please complete bro.
Yeah, so in all these SLPs, the only prayer that you will ever find is that grant leave to appeal against the impugned judgment and order. So I think prayer is never important to mention, because तुम्हें हर SLP या हर civil appeal में यही prayer मिलती है. In a writ petition, the prayer becomes important because वहाँ पे substantive चीजें पूछते हैं. So you have to mention the prayer in a writ petition, and if there is an prayer for interim relief, then you have to mention that in the SLP or civil.
सेम वही रिट पिटिशन का ही बताना था कि रिट पिटिशन में हमेशा कोई ये नहीं कहता अलाउ द रिट पिटिशन, दे आस्क फॉर सर्टेन डायरेक्शन, दे आस्क फॉर सब्सटैंटिव रिलीज, जैसे सत्यम ने बोला है, तब मेंशन करना ज़रूरी है, तो वो भी बहुत शॉर्ट में, क्योंकि वो बड़े बड़े पैराग्राफ लिखते हैं, सब कुछ शॉर्ट में करना है। इसके अलावा आई थिंक सो वी कैन जस्ट क्विकली गो ओवर द रिसर्च मेमो वाला पार्ट एंड ये सब। सो लाइक
Yes. Baki, you told them about the live law digests and everything, no?
हाँ बता तो दिया है, वरना एक और बार दोबारा बता दे, वरना तू
Okay.
भी एक बार बता दे, तेरे साथ ही बताया क्योंकि उस टाइम तू आया नहीं था। सो लाइक
Okay. So just 20 seconds. So for the current affair portion, I only refer to the live law digests which are published. Top 100 judgments of the year, top 100 judgments of this quarter, January to March. So I only refer to those, and it was more than enough. I was able to attempt every question which was asked in the current affairs portion, and every question was there in the live law ke digest and summaries which they published. So I think that should be your go-to resource. Keep following the proceedings as Romit told, and I think you should be good to go for the current affairs portion.
इवन दिस साइट इज ऑल्सो गुड, लाइक अगर तुम्हें लाइव लॉ के भी बहुत सारे हैवी लगे, इवन दो लाइव लॉ शुड बी नंबर वन लाइक सत्यम सेड कि उसके सारे डाइजेस्ट पढ़ लो, बट अगर तुम फॉर कंस्ट्रेंट रीजन तुम्हें लग रहा है कि लाइव लॉ भी नहीं कर सकते, यू कैन सी जो भी लाइक धीरे धीरे मैटर्स टेक अप हुआ है, यू कैन सी ऑल ऑफ देम, लाइक दिस इज वन ऑफ द मैटर जो मैं मेंशन करना भूल गया, जो हमारा इनफॉर्मल लिस्ट है यहाँ पे जो बना रखा है, बट दिस इज ऑल्सो वेरी इंपॉर्टेंट। सो लाइक ये अभी अभी लिया गया था, these kind of things will be asked, so you can quickly go over here, you can filter भी कर सकते हैं यहाँ पे कि भाई मेरे को पेंडिंग नहीं, मेरे को डिसाइडेड चाहिए, तो यू कैन सी कौन कौन से डिसाइडेड है, एंड देन यू कैन ऑब्वियसली चेंज न्यू एस से ये सब करके यू कैन सी, ठीक है। तो दिस इज ऑल्सो गुड साइड, लाइव लॉ शुड बी द स्टार्टिंग पॉइंट, सुप्रीम कोर्ट ऑब्जर्वर, उसके अलावा यू कैन गो SCC ब्लॉग एंड साइड केसेस, यू कैन गो एंड रेफर टू दैम। ये एक और लाइकली लिस्ट है इन एडिशन टू द लिस्ट जो सुप्रीम कोर्ट ने पब्लिश करा है कि ये सारे डिसीजंस आ जाने चाहिए, तो ये सब भी पढ़ लेना, बट इनके तुम्हें रेशस पढ़ना है, और ये सारे के बारे में तुम्हें मोटा मोटा पता होना चाहिए कि भाई क्या बोला गया है आर्टिकल 30 के बारे में, इन सारी जजमेंट्स ने क्या बोला गया है इस्टेब्लिशमेंट एंड एडमिनिस्ट्रेशन के ऊपर, पार्लियामेंट्री प्रिविलेज के ऊपर क्या बोल रखा हुआ है, ठीक है, अमेंडमेंट में क्या बोल रखा है, रिजर्वेशन में क्या बोल रखा है, थोड़ा बहुत तुम्हें बस पता होना चाहिए था। नाउ बिसाइड्स दिस रिसर्च मेमो में लाइक यू विल ऑब्वियसली गेट अ फैक्चुअल सिनेरियो, मैं दिखा देता हूँ, लाइक फॉलो द क्या कहते हैं सैम्पल गाइड, क्योंकि हम लोग एटलीस्ट मैंने तो रिसर्च मेमो के लिए प्रिपेयर नहीं किया था, और ना ही सत्यम ने भी रिसर्च मेमो के लिए प्रिपेयर किया था। दिस इज समथिंग दैट यू जस्ट हैव टू अटेम्प्ट इट इन अ ब्लाइंड साइडेड वे फॉर द फर्स्ट टाइम, एंड क्या कहते हैं तुम लोग क्या कहते हैं जस्ट अप्लाई योर ओन बेस, तुम लोग ब्रीफ बनाने के देखोगे तो यू विल अंडरस्टैंड कि किस तरीके से फॉर्मेट होना भी चाहिए, ठीक है। So you just have to go into this head first. You'll see.
So one way of practicing the research memo could be. No, I'm sorry. Please.
नहीं, please बोल. मैं तो कह रहा हूँ.
Yeah. तो मैं ये कह रहा था कि it is difficult to find problems like this for practice purposes. So what you can do is, I think DJS के जो mains के question paper होते हैं, they ask some similar questions where they give you a very elaborate statement problem. And then you have to sort of give an opinion on this. You have to counsel a client that has come to you asking for a opinion on some specific aspects of the law. So to attempt a question like that, you take one question from the DJS, you see what all laws are involved, you keep that open in another window in your system itself. You open the Bare Act if you have the hard copy. Then you also refer to your textbook for all the cases which are pertaining, some of the landmark cases which pertain to those sections. So, for example, let's suppose a question is given to. Why? इसीलिए. So, because for practice you'll have to keep all of this, because in the exam you're going to get extract of Bare Act and extract of landmark judgment. But in the DGS paper, of course, you do not get that. So you take the question from, let's say, DGS mains, and let's suppose the client has come to you seeking your opinion on 438 CRPC, whether he can get bail in a criminal offense pertaining to murder of two people or not. This is the problem that is given to you. Certain fact situations are given that there is some improvement in the FIR and the 161 statement which is recorded and stuff like that. So what you do is you keep the CRPC Bare Act with you, open section 437, 438, then you open 302 of IPC, and then you open some of the landmark judgments which pertain to bail. Gurbakh Singh Sibia, for example, you can open that. Uh, just open 3 or 4 judgments, because in the question paper you're going to get extracts from 5 to 6 landmark judgments. 2 or 3 of them will be relevant, 2 and 3 of them will be irrelevant. So the idea behind this question is that you're able to figure out which judgments I can use to substantiate my argument and which judgments I cannot use. So if you have a universal Bare Act, I think even in 438 you will find that 5-6 judgment ke excerpts they have given. So open SCC copies or open SCR copies of those judgments, keep them somewhere in the computer, and then you start practicing for this. So if a question is given to you, you firstly in 2 lines very quickly mention the facts which are given to you. Then you mention what are the issues for determination. And from the facts, you have to decide that there are 2 issues. First issue could be that whether material change in the statement given by the complainant in FIR and 161 statement is a ground for grant of bail in 302 cases. So this is an issue that you frame. Then you can frame another issue. Uh, so of course the question will be more elaborate. So you'll be able to frame issues from the fact statement which you have. Mention 2 and at max 3 issues, because you have to attempt all of this in 1 hour. I ended up framing 4 issues, but I could only answer 3 of them very satisfactorily. One of them मुझे ऊपर से लिखना पड़ गया था. So then first you mention brief facts, then you mention issues for determination, then you mention relevant statutory framework or relevant statutory provisions. Then you quickly mention section 438 of CRPC, and you look at the Bare Act and you briefly summarize it in your answer sheet. Then you mention section 302. You can also mention section 161 of CRPC, which is about recording of statement by the police during investigation. So you do this, and then you come to the analysis portion. And in the analysis portion, you'll have to refer to the relevant case laws. You'll have to take the understanding which is given in the relevant case law and then apply it to the factual scenario. So in the analysis portion, what you have to do is you have to apply the statutory provisions and the precedents onto the facts that you have mentioned in the brief facts other. You do this in the analysis portion. The analysis portion is going to take the maximum amount of time. So if you're doing it in 1 hour, then I think 30 minutes should be for analysis, 5 minutes for facts, 5 to 10 minutes for statutory provisions, 5 minutes for issues, and 5 to 10 minutes for conclusion. After you've done the analysis portion, you come to the conclusion. If the question is similar to the one which you were given previous year in the examination, so there we had to give advice to a client regarding adoption and custody rights of her minor daughter. So in the conclusion, in 2-3 paragraphs, you decide, you give a paragraph each on first issue, how you have decided the first issue. On first issue, I would advise my client to take these steps, approach this forum. Then you come to the second paragraph and you'll answer the second issue. On second issue, this is the possible conclusion that I can draw. This is the possible advice that I would like to give to my client. And this is how you end this, what is it called? Draft research memo. I think this is how a draft research memo looks like. Romit, if you have anything to add.
Yeah, absolutely. बहुत ही brilliant तरीके से you have told भाई क्या exactly format होना चाहिए. This is exactly what even I was going to say. यही format होना चाहिए कि you first read the entire material. Most often than not, material read करने के बाद तुम्हें questions नहीं मिलेंगे. लास्ट में बस ये लोग कह देंगे प्लीज़ एडवाइज या प्लीज़ प्रिपेयर रिसर्च में आंसरिंग द क्वेरीज ऑफ ये सब, बट दे वोंट गिव यू एग्जैक्ट क्वेरीज कि क्या क्वेरीज है. तो यू विल ऑब्वियसली हैव टू इन योर माइंड फॉर्मुलेट सर्टेन इश्यूज. आई वुड से 2 या 3 के बियॉन्ड मत जाना. 2 इज़ गुड, 3 कर पाओगे तो बहुत बढ़िया है. ठीक है, 3 इशूज़ फ्रेम करने का. नाउ यू स्टार्ट अटेम्प्टिंग योर क्वेश्चन. पहले आ जाएगा ब्रीफ फैक्ट्स, जिसका तुम बहुत धीरे मोटा बता रहे हो कि क्या क्या हुआ है, एंड बहुत ही कम लिखना है तुम्हें. ठीक है, एंड लास्ट में तुम्हें बताना है कि मेन ग्रीवेंस क्या है यार लास्ट की लाइन में. वंस यू डन विद द ब्रीफ फैक्ट्स, यू गो एंड फॉर्मुलेट द इशूज़ कि ये 3 इशूज़ है. एंड देन एनालिसिस पार्ट में while answering each issue you rely to not only the relevant case laws जो उसके लिए relevant है, कुछ irrelevant होगा जैसे सत्यम ने पॉइंट आउट करा है. डोंट गेट कंफ्यूज, ओनली साइड द relevant ones. उसके क्या relevant paragraphs है, relevant provisions जो भी तुम्हें Bare Act दे रखे होंगे, ये relevant provision इस issue को आंसर करने के लिए, एंड उनको कनेक्ट करना है जो भी relevant facts है. ठीक है, तो these 3 things से तुम्हारा एक issue आंसर होगा. Once you've answered all 3 issues, then you go jump to the conclusion where you just summarize whatever finding that you made in क्या कहते हैं issue number 1, issue number 2, issue number 3 conclusion में आ जाएगा. So like sample paper में I think so everyone would have gone through ये partnership and negotiable instruments पे था. Very simple. ठीक है. We come to क्या कहते हैं question paper में. I think so question paper का ये रहा. So इसके अंदर we had like Satyam said we had a question on उस पे child custody पे. So effectively like what if I'll going to summarize it for you, हुआ ये था कि child किसी और के custody में था. The child was a specially abled kid. That kid was taken out of the custody of his grandparents, जो उनके क्या कहते हैं of her grandparents, जो क्या कहते हैं उनके grandparents को lawful custody था by क्या कहते हैं her mother, and she was taken away to her mother's home. Now her grandparents wanted relief कि we just want a child's custody back. ठीक है. So you will see यहाँ पे question कर रहा है the grandparents approach you to understand the law on custody of minors and legal way. They are only interested in expeditiously regaining custody of the child. ठीक है. Who they have learnt is so and so, so and so. ठीक है. तो you have relevant facts. Especially able child था. She is emotionally distressed. Lawful custody grandfather grandparents के पास था. Mother क्या कहते separate थे husband थे. But despite that she unlawfully took her away. They have given you acts के copies. HMGA, Guardian Wards Act. And they have given you bunch of decisions also जिसके अंदर extracts है. ठीक है. Now you have to first go through all this material. Well, first formulate in your mind कि क्या issue होना चाहिए. ठीक है. Read this, formulate issues and then again come back. Now to answer these issues you will have to go through the act. So number one I would suggest like for this example HMGA you will have to see या कोई भी irrespective कोई act होगा. Does this even apply to your facts or not? So check the application of the act. ठीक है. Once you check the application of that, इस एक्ट के अंदर क्या क्या रेमेडीज है या फिर क्या क्या पेनल्टी स्टिपुलेटेड है. पेनल्टीज वुड हेल्प यू गेनिंग कि क्या क्या इलीगल था, क्या क्या नहीं करा जा सकता. रेमेडीज से पता चलेगा कि क्या क्या तुम रेमेडीज अवेल कर सकते हो इसके अंदर. ठीक है. तो इसके अंदर यू विल सी क्या कहते हैं वेलफेयर ऑफ माइनर टू बी पैरामाउंट कंसिडरेशन. तो दिस इज अ गाइडिंग फैक्टर. दिस इज हाउ ऑल मैटर्स ऑफ चाइल्ड कस्टडी आर टू बी डिसाइडेड अंडर HMGA एक्ट इफ यू फॉल विद इन HMG एक्ट. तो इफ वंस यू चेक द एप्लीकेबिलिटी यू सी कि हाँ भाई मेरे फैक्ट्स में अप्लाई कर रहा है. दिस इज द डिग्री. सो यू विल ऑब्वियसली ऑल योर आंसर्स विल हैव टू बी इन अकॉर्डेंस टू सेक्शन 13 की दिस इज इन वेलफेयर ऑफ दिस चाइल्ड, दिस इज इन वेलफेयर ऑफ दिस चाइल्ड. दैट्स वाई ये होना चाहिए था. बिसाइड्स दिस यू विल सी क्या कहते हैं यहाँ पे यू विल सी टेस्टिमेंट्री पावर्स एंड यहाँ पे इन पावर्स ऑफ नेचुरल गार्डियन के अंदर यू विल सी यहाँ पे कोर्ट्स को भी पावर दे रखा है टू रीगेन कस्टडी. सो यू विल हैव टू मेंशन दिस. बिसाइड्स दिस गार्डियन एंड वार्ड्स एक्ट के अंदर बस खाली टाइटल ऑफ गार्डियन और ये सब दे रखा है. देयर इज नॉट रेलेवेंट मटीरियल. हमारे लास्ट टाइम के पेपर में नहीं दिया था. बट अगर तुम रेलेवेंट केस लॉस के अंदर आओगे तो देयर वाज दिस वन केस. लेट मी सी कहाँ गया. वन सेकेंड. I had highlighted it. Yeah. So over here. तो दिस इज बेसिकली अ रिप्रोडक्शन इन अ केस जिसके अंदर तुम्हें गार्डियंस और वार्ड्स एक्ट के बाकी सेक्शंस के बारे में बताया जा रहा है. सो इफ यू चेक पहले वाले में उसके अंदर बाकी सेक्शंस नहीं दे रखे थे. खाली यहाँ 24 से लेकर 26 तक दे रखे थे. बट ओवर हियर इट्स गिविंग यू डिलिनेशन ऑफ एंटायर सेक्शन स्टार्टिंग फ्रॉम सेक्शन 6 टिल सेक्शन 12 जिसके यहाँ पे सेक्शन 12 में यू कैन सी इंटरिम पावर्स एंड इंटरिम रिलीव करने का भी स्कोप है. सो नाउ वंस यू रीड ऑल ऑफ दिस यू विल सी क्या कहते हैं इसके अंदर मोटा मोटा तुम्हें 3 रिलीफ के बारे में बताया जाता है. हैबियस कॉर्पस रिट पिटिशन, एक तो सेक्शन 12 से इंटरिम रिलीफ जो मैंने अभी दिखाया, एंड देन अंडर द सेक्शन 16 जहाँ पे यू कैन टेक नॉर्मल कस्टडी, हाउ चाइल्ड का कस्टडी लिया जाता है फ्रॉम अ फैमिली कोर्ट. नाउ देयर क्वेरी वॉज सिंपली रिस्ट्रिक्टेड टू वन क्वेश्चन ओनली कि हम लोग क्या कहते हैं एक्सपीडिशियसली रिलीफ कैसे ले सकते हैं. So now you break it down into electing relief. So like expeditionary relief लेने के लिए तुम्हारे पास now we have 3 available reliefs. First issue because whether habeas corpus is क्या कहते हैं what would you say is an appropriate relief in this instant case. Can there be interim relief can be sought under this case. And third would be child custody वाला जो normal process है section 16 या 14 of the HMG Act जो भी था. I can't remember that. In any case now you'll start answering all of this. So habeas corpus इसके अंदर क्यों मूव करा जा सकता है. If you'll read case laws, you'll cite case laws, you'll cite constitution का article even though it's not given but you can obviously cite it. Article 32 या 226. उसके अंदर now you'll correlate it with the facts. Because the child is now emotionally distressed and क्या कहते हैं she was a specially able child. That's why habeas corpus is most appropriate. Writ jurisdiction is like Satyam told is a discretionary jurisdiction. But इस केस में discretion क्यों exercise करना चाहिए? Because she is a specially able child. She is in emotional distress. इसके अंदर normal remedy की दो क्या कहते हैं इस क्या कहते हैं what you call effectuous. Writ petition urgency की वजह से is much more necessary. So that's how you answer the first answer. देन इंटरम रिलीफ भी यू कैन सी कि इंटरम रिलीफ चाइल्ड कस्टडी क्योंकि हमारे पास ही रहना चाहिए. सो इंटरम रिलीफ यू आर सीकिंग फॉर चाइल्ड कस्टडी. मेन रिलीफ इज चाइल्ड कस्टडी परमानेंटली तुम्हारे पास रहेगा. इंटरम रिलीफ इज कि ड्यूरिंग द डिस्पोजल ऑफ द परमानेंट कस्टडी केस तुम्हारे पास रहेगा. अब क्यों इसके अंदर ये रहना चाहिए क्योंकि पहले भी ग्रैंड पेरेंट्स की कस्टडी में थी. ठीक है. दूसरी चीज़ क्या कहते हैं, शी हैज स्टेड हियर विथ उसका स्कूलिंग वूलिंग सब कुछ यहीं पे यू विल सी दैट इन द फैक्ट सब कुछ लिखा होता है. बिकॉज हर स्कूलिंग वॉज ऑलरेडी जहाँ पे वो ग्रैंड पेरेंट्स के साथ रह रही थी वहीं पे उसका स्कूल था, वहीं पे सारे फ्रेंड्स थे. कस्टडी पहले से ओरिजिनली वॉज विथ ग्रैंड पेरेंट्स. दैट्स वाई इंटरम रिलीफ भी इसके अंदर ग्रांट करना देना चाहिए. एंड व्हेन यू कम टू आंसरिंग द मेन वाला कि क्यों कस्टडी शुड बी परमानेंटली ग्रांटेड यू एज अ मेन रिलीफ, तो देन यू अगेन साइड के अनलॉफुली तुम्हारी कस्टडी से लेके गया था. द वाइफ वॉज सेपरेटेड, द चाइल्ड अगेन हैज बीन लिविंग विथ यू, पैरामाउंट कंसिडरेशन ऑफ वेलफेयर ऑफ द चाइल्ड, तीनों इश्यूज में आ गया. एंड दिस इज हाउ यू विल आंसर क्या कहते हैं रिसर्च मेमो वाला क्वेश्चन. नाउ वेरी क्विकली, आई मीन इज सत्यम देयर?
Yes, yes, bro. Yeah.
Anything you want to add, bro?
Yeah, in this just one suggestion I would give is the as a lawyer, because you have asked to attempt this question as a lawyer, that what advice would you give to your client? So of course there can be 10 ways of getting that relief which your client is seeking. You'll have to in the beginning itself, after going through the judgments, after going through the provisions, decide that okay, I'm going to stick with these two strategies and I'm going to only advise my client on these two approaches of obtaining the relief that they want. Because if you go into 10 ways, then you'll firstly not have enough time to mention that, and secondly you will end up getting confused and also confusing your client that what actually they're seeking. So
and that
be
defeats
very
the purpose
specific.
of the research memo only. तुम्हें expeditiously
Yeah.
relief दिला के बस मेन चीज बतानी, ये नहीं कि तुम सब कुछ
Yes.
लॉ बता रहे हो. It's not a research paper, it's a research memo.
Yes. So decide the issues very smartly. That okay, these two issues will take care of everything that my client wants, and also see what are kind of issues which have been referring in the case law excerpts that have been given. So if example, for example, 6 case law excerpts are given, you see that every case law or 4 or 5 of them deal with 2 issues definitely, and then they go to the third or fourth or ancillary issues. So take those issues which are dealt in almost every case law, and then build your argument around those issues so that you have authority on those questions of law as well.
And likewise केसेस के अंदर केसेस और दिए रहेंगे. यू विल हैव टू अगेन साइफन एंड शाफ्ट द ग्रेन एंड सी कौन सा रेलेवेंट है कौन सा नहीं है. ठीक है. एंड इन टर्म्स ऑफ लाइक मेकिंग दिस, आई मीन लाइक यू कैन फॉलो लाइक पेन पेपर वाला ही तरीके से, जैसे लाइक फॉर्मेट तुम्हें सैम्पल वाले में दे रखा है, ब्लैक से हेडिंग डाल देना, ब्लू से ये सब करना, एवरीथिंग पॉइंट वाइज करो. आई वुड सजेस्ट. ठीक है. बहुत छोटे में लिखो, इन दिस केस इट वॉज हेल्ड दिस एंड दिस दिस दिस. ठीक है. साइटेशन दे दिया करो, बढ़िया रहता है. ठीक है. सब पॉइंट्स भी बना सकते हो. ठीक है. वेरी क्विकली यूर रिकैपिंग की लाइक इसके क्या एसेंशियल इंग्रेडिएंट्स है, क्या है वो है, यू कैन डू ऑल ऑफ दिस काइंड ऑफ थिंग्स. ठीक है. नाउ कम्स द लास्ट
You can
पार्ट.
also honestly make a table that issue this and what different courts are held. You can make a table delineated so that lesser space will be used and you'll not have to frame proper sentences, because in a table you can just give the keywords and you can explain the issue and how it was written. So
Correct.
while dealing with case laws, I think you can make a table and give a better structure to the research memo. Because
And
that
it
is
will
generally
save
how we
space.
make a research memo. Yeah, in office, we generally refer to make tables, or we do not use a very formal research paper language while making a research memo.
And try to use lawyer wala language also while attempting answer. Use word except like prima facie, stricto sensu, inter alia, ठीक है, ex facie, illegal, these kind of things you should tend to use. ठीक है. Yeah. Make it like you're making a draft, not like you're answering like very random answer. कॉलेज वाले आंसर की तरह नहीं देना तुम्हें. ठीक है. And
Yes, yes. If you use good legal terminology, then I think it will fetch you some extra marks.
yes. And besides this तुम्हारे इसके अंदर एक और क्वेश्चन ऐड कर दिया विच इज़ लाइक डीजीएस वाला ही क्वेश्चन कॉपी पेस्ट कर रखा है इन्होंने. बेसिकली तुम्हें 5 क्वेश्चन देंगे जिसमें से आई थिंक सो तुम्हें एक अटेम्प्ट करना है, इज व्हाट आई
Yes, yes. One out of 5.
या. सो एनालिटिकल क्वेश्चन 1 out of 5. उसके अंदर भी जो तुम्हें जुडिशरी में बताते आई थिंक सो कुछ इशू रीजनिंग एनालिसिस, कुछ IRAC या समथिंग कुछ ऐसे ही कुछ होता है. आई डोंट
So
रिमेम्बर.
generally, what we used to follow in debating circuit is we use the ARE method.
Yes.
You give the argument, then you give the reasoning, and then you give the example. So ARE. And I
So-
think it should be enough for this as well, because
Correct.
development of an argument through reasons and appropriate examples. So it's ARE only that they're looking forward to,
Yeah.
as you can see in the highlighted portion.
सो तुम लोग देख लेना, ये क्या कहते हैं, इसके अंदर तो लाइक हमने भी कभी अटेम्प्ट नहीं करा है, बट रिमेंबर दैट ऑल 3 क्वेश्चंस कैरी इक्वल वेटेज एज फार एज आई रिमेंबर. दिस इज आल्सो फॉर 75 मार्क्स, राइट? ब्रीफ प्रिपरेशन नहीं, ब्रीफ प्रिपरेशन इज 150.
Okay.
ब्रीफ
Then
प्रिपरेशन
I was
150
I
एंड
wrong
दीज
at
टू आर
that part.
75. सो लाइक रिसर्च मेमो और ये सब में चलो ठीक है, तुम लोग फिर भी obviously answer according to marks. Brief making में don't skimp on anything. That is the main relevant part, and that is basically your work that you will be doing even after you selected as a law clerk. ठीक है. रिसर्च क्वेश्चन में तुम्हें नॉर्मल क्वेश्चन ही देंगे, ठीक है. दिस सॉरी क्वेश्चन 3 में, एनालिटिकल क्वेश्चन में. रिसर्च में तुम्हें इशू दे रहे, एनालिटिकल क्वेश्चन में तुम्हें डायरेक्टली क्वेश्चन पूछे, कोई फैक्ट्स में घुमा नहीं रहे, ये नहीं कर रहे, वो नहीं कर रहे. नॉर्मल क्वेश्चन तुम्हें दे रहे, डायरेक्टली है, डायरेक्टली तुम्हें आंसर भी करना है. तुम्हें कोई आंसर नहीं, तुम्हें कोई मटेरियल भी नहीं दिया जाएगा.
Also, I was going through the sample 5 questions that they've given for this part 3. I think 4 of them are from constitutional law and 1 is from criminal law. So
कहाँ
I
पे
think
दे
this
रखा
is there is a sample paper which they have uploaded.
मेरे को दिख नहीं रहा. अच्छा ये है क्या? या यही है, ये रहा.
So if you look at it, first is of course Swadai Federal, so it's constitution. Second is part 3. Third is also part 3, sort of constitutional court. And let's not call it part 3. It's about the Supreme Court. Then there is a criminal, and then again there is a question pertaining to the constitutions. So I think if you can just go through your material for constitutional law, which you refer to in college for examinations, that might help you. If you have notes for constitutional law, then just revise all of these basic concepts: federalism, basic structure doctrine, powers and functions of Supreme Court, ordinances, legislative competence, list 1, list 2, list 3. All of this you just read it once, revise it so that you can attend this in a better manner.
एंड तुम्हारा आंसर एक पेज के साइड से बियॉन्ड नहीं जाना चाहिए. 350 to 500 वर्ड्स का है, तो मतलब एक पेज में भी कम ही स्पेस बचा रहना चाहिए, ठीक है. ज़्यादा मत आंसर करना, पॉइंट वाइज आंसर करना. पैराग्राफ में भी कर सकते हो. मैं आई प्रेफर पॉइंट वाइज में आंसर करना. इट मेक्स रीडिंग ईजियर एंड इट मेक्स और जो भी कीवर्ड्स और ये सब होते हैं तुम्हारे क्वेश्चन के आंसर में बहुत ही अपेरेंटली दिखता है. तो जब भी एग्जामिनर जा रहा होता है उसे दिख जाता है कि हाँ भाई इसने ये सब लिख रखा है सब कुछ.
Yes, at least, so, for example, if you're going to do it in 3 parts, argument, reasoning, and examples, then argument you can do point-wise, that these are the 3 arguments in favor of this proposition. Reasoning, maybe you can do paragraph-wise, because they also want to look at your style of writing, how well you're presenting the idea. So maybe reasoning you can do in paragraph-wise, 1 paragraph and then 3 pointers. You can use both of them. Examples, use. So paragraphs and pointers I would suggest, or whichever style suits you most.
Now lastly coming to preparation part for MCQ wala. Very quickly going through this. Pick up any book that is dealing with judiciary, ठीक है. In those judiciary books you'll find MCQs which will be subject wise MCQs. So कौन सी MCQs will be separately.
I would suggest only go for Delhi Judicial Services, bro, because बाकी states में the questions are very memory based.
Yeah, even I would suggest that. Go for DJS MCQ books. Do them regularly, practice them. Let's say you do 15-20 questions of Constitution today, then do 20 questions of CPC. Next day, again go back and do those questions of Constitution and do something else also. So that way you'll be revising also those questions and you'll be also learning something new. Don't go ahead into this exam thinking that first I'll complete Constitution, then I'll only start with IPC. No, start with all of them together, because each part in the MCQ, each subject I would rather say in this in part 1 carries equal weightage, equal number of questions, and they can ask you anything. Okay, so don't leave it on luck and don't leave it on that I'll first complete Constitution, then only you'll be leaving out most of the parts unprepared. Don't do that. Focus on questions. Through the question, doing the questions only, that will give you an idea of what the concept is, and then you can also read upon them, and that's how you'll go ahead and develop your concepts. Otherwise you can pick up any guidebook, your study material that you relied upon in college or are relying upon in college. That will also help you develop your concepts on all the 5 subjects. Latest developments we've already told: live laws, Supreme Court observe, and all of this. There's a new book coming from, I think so, Arif has also edited and contributed in that book.
Yeah, Arif is going to get a book published by single
Yeah, he is
publication.
publishing one book. We are not promoting that, or we're not telling you to buy and sell, buy that particularly, or we're not trying to increase its sales. Okay, it's just a suggestion. If you want, you can take that. Otherwise, there is one more book that's an older version of the book from the same publication. Single Law Clerks Come Research as a book. Single. You can even go for that. That is how I had initially prepared, because there at that time RF wasn't there to come to my rescue. So yeah, but you can again take this book also, or you can take RF's books. It's not yet launched, so I don't know what its name is, but agar hoga, we'll update and we'll let you know. In any case,
One thing I would suggest for MCQs is what I did. So I did not have a lot of time to prepare for the MCQs. My examinations got over on 30th and 31st, and I had the exams were on 4th June. So I had 3 days of preparation. What Arif and I did, we used to study together. We only went through the illustrations which are given in the Bare Act. So if you go through CRPC, IPC, and evidence and contracts, 4 of these subjects have a lot of illustrations which are given. Constitutional law does not have that, of course. But for these 4 subjects and CPC also, I would strongly suggest that whichever are the important chapters, for example, the offences relating to human body in IPC, you go through the important sections and you look at the illustrations that have been given in the Bare Act. A lot of questions which were asked in the examination were directly from illustrations. The Bare Act was the provision was reproduced, and in the options you had the illustration that which would be applicable here, or an illustration would be given from one section, and then the question would be that which offense is it? Is it misappropriation of property? Is it theft? Is it robbery and all? So I would strongly suggest that go through the illustrations. They will give you a lot of clarity, and will also come directly into the examination in the question.
correct. Like even right now, I just scrolled 3 pages and I could see at least 6 questions जो illustrations में ही से ही थे. Extortion के
Yeah,
ऊपर,
so maybe I
robbery.
was lucky in that sense that most of the questions were from the illustrations. But I think if you're going to ask application-based questions, which they are going to, then they'll have to give questions from illustrations only.
Correct. They will have to. And like again, emphasizing, you don't have to learn the provision, they're giving you the entire provision. Order 5 Rule 15 is reproduced over here.
Chalak has asked a question. Judiciary preparation books along with Bare. I think yes. So I did it even without the judiciary preparation books. I only refer to the Bare Acts and the provisions mentioned therein. If you can refer to both because you have still a month to go, then you can do both of them. But I would again suggest that please, if it's, for example, if you're giving 5 hours to the preparation every day, then devote 3 to 3.5 hours to part 2, and maybe 1.5 hour to part 1, because
Correct.
it's 300 marks versus 100 marks.
But of course, you have to clear part 1 to even have your
Yeah,
part 2
yeah,
paper
yes.
considered.
Yes.
Don't take the
I
benchmark of
know.
part 1 ki I have to only score minimum 50%.
Yeah.
Aim for 80. That is the minimum, I would say.
So it depends how your luck is that day. I was able to score decent in part 1, but my part 2 was not that great. But my part 1 saved me and helped me get a good rank. For
Same.
Arif, it was different. He got great marks in part 2. His part 1 was decent. But still, you'll see that because Arif's part 2 was better, he got a much better rank than I got.
Same.
So, again,
He
if
got
you
a much
do
better
better in
rank.
part 2, yeah. So if you do better in part 2, then you're going to get a better rank and your prospects will be better.
Correct.
But again, you need to score 60, 70 at least out of 100 to even compete in the race.
Yeah. Otherwise, you'll just end up in the very bottom of the panel, and that would be of no good. You won't get selected. You won't get placed anywhere.
I think that's it from my side, Romit. If
Same.
you have anything,
I've
or if
even
anyone
turned off
else
my
has any
presentation. I
questions.
don't have anything else to contribute now.
It
I
was a
mean, we
great
can
time
go on
indeed.
about how to be good law clerks, but that's probably we'll save it for another session once you've cleared the
I
exam.
think we'll have to get some other locals for that. We are not.
No. If
So
I
that's
had
what
the
for
ability, I'll choose you only, bro. My preference.
Okay, thanks. I'll Google pay you 500. If any questions are there,
No worries, guys. No worries, guys. I mean, like, we didn't have this session at our time. We had nobody to guide us. This paper was completely new because the scheme had changed and everything had changed. This part 2 was completely new to all of us. So I mean, like, we also wanted at that time that somebody was there to guide us. That's why we're doing this. So
The marks will get added. Pass marks are not merely of a qualifying nature. They'll get added to your final total. So you not just have to score above 50. The better you do in both parts, the better your chances of ending up in a judicial office are.
alright guys, then I think so we'll just close the session. Thank you guys for coming and all the very best. If you need any help, you can message me, Satyam, Arif anytime. And we'll see you later on. कोई भी डाउट हो कभी भी तुम मैसेज कर सकते हो. इट्स नॉट लाइक कि भाई हमने एक सेशन ले लिया अब हम इग्नोर करेंगे सारे मैसेजेस. यू कैन अप्रोच अस as long as we have time. We will completely try to help you. Okay, bye guys. Thanks Satyam.
Yes, now you like to drop your email ID or you want to give your
लिंक्डइन पे सही है. हम तीनों लिंक्डइन पे आई थिंक सो दैट्स बेस्ट भाई. मेरे ईमेल पे ऐसे ही बहुत ईमेल्स आते हैं.
drop it for both of
You can message us on LinkedIn. ठीक है.
Get in touch with them.
Yeah. And we'll update the post. यहाँ पे सारे मटेरियल डाल देंगे हम लोग जितना भी हमने रिलाई करा है.
Yes, we'll do that.
So Surbi, you can
Bye, Romit. See you.
जो भी हमने इस एग्जाम में बताया मतलब इस सेशन में बताया फॉलो दैट ओनली. दैट विल हेल्प यू प्रिपेयर फॉर योर नेक्स्ट अटेम्प्ट. ओके, व्हेन यू विल बी एलिजिबल. चलो बाय गाइस, सी यू.
Bye, see you guys. Bye.
बाय सत्यम.